Honorable, the Vice President.
Is Senator Mark?
Thank you, Mr. Vice President. Yeah, Mr. Vice President, I rise to make a contribution to a bill that has been fundamentally altered. The last check I made, there were some 33 amendments to the legislation that the AG has circulated, and there are a minimum of 2 new clauses. So when we look at what we had to deal with today, as of June, July, there has been a 360 degrees turn about by the Attorney General, turn around, I should say, rather. In other words, you have actually gone around almost.
Just 1 second.
Mr. Vice President?
I am a little confused myself. Are you contributing to the debate as it's moving forward, or are you responding to the discourse that may have been had at lunch?
No. Well, I don't know. Are you allowing me to contribute now, or you want me to continue?
So you're contributing to the debate itself?
No. I would like to get your advice.
So you're seeking my advice. You're not actually starting the debate?
No, I haven't started.
All right, well, quickly, if you have a comment to make it. And then I'm going to call on the person to move forward the debate, because I'm assuming that there was some discourse at lunch,
Yes.
and that the debate is moving forward.
Well, you had ruled accordingly, and that is what we are being guided by.
So are you guiding me now as to the discourse that occurred at lunch?
No, what I'm saying that based on your advice to us, we will. I'm just seeking some clarification from the Attorney General before I get into the meeting.
All right, well, do you have further comments in relation to that particular discourse? Because...
I just want to get the clarification from him before he comments.
Okay, right, well, there's no need to say any more. I'll call in leader of government business to officially respond to the discourse and close off that section of it.
Mr. Vice President, there's no further discussion during the break. I think before the break, we agreed on the procedure that we would take an hour and 15 minutes and resume, and on the resumption, we'll continue with the debate on this bill. I think that the question that has been asked is whether there was supposed to be a procedural motion before we continue, and I think the answer is no. We've complied with all the formalities, and it is now for Senator Mark to speak.
Right, and I think that is it, because the question was put before we had the discourse. So as it is right now, the debate is continuing with the first responder to the motion and the bill being piloted by the Attorney General. So who is the first responder? All right, Senator Mark?
So I can speak?
Yes, so you can speak now.
Thank you very much, Mr. Vice President. Yeah, Mr. Vice President, I rise to respond to the Attorney General's presentation here earlier this morning, in which the Attorney General sought to convince this House, the Senate, of the need to support the current legislation with the accompanying amendments. Mr. Vice President, no one can argue with efforts by any administration to make life more comfortable and to create convenience for the public. There can be no equivocation or major discussion on that point. So we understand that the effort that is being made here is to allow the public who are in contact with the courts to use a method where they can transact their business electronically, and the government has brought this legislation to effect that kind of thinking as they seek to, as someone said earlier, to modernize how we do business. But Mr. Vice President, I must admit to you, I was taken aback by the Attorney General when he made his contribution and he was making reference to several amendments that is now before this Honorable Senate. And one of those amendments I wish to bring to your attention very early, that is part of this legislation, is Clause 4A of the bill that has been recirculated, or I can say the amendment that we have before us. The Attorney General has introduced an amendment which states, and I want to quote, "The Exchequer and Audit Act shall apply to this act, and in the event of conflict between this act and the Exchequer and Audit Act, this act shall prevail." Mr. Vice President, I am astonished that an Attorney General who is the guardian of the public good can speak and can pilot such an amendment and ask this Senate to approve it. We cannot approve it. Mr. Vice President, may I take you to the Exchequer and Audit Act? Mr. Vice President, the Exchequer and Audit Act 6101 states on page 5, it is an act to provide for the control, Mr. Vice President, this is the language of the framers, to control and management, for the control rather, and management of the public finances of Trinidad and Tobago, for the duties and powers of the Auditor General, for the collection, issue, and payment of public monies. Mr. Vice President, may I repeat? For the collection, issue, and payment of public monies, for the audit of public accounts, and the protection and recovery of public property, and for the control of the powers of statutory bodies and for matters connected therewith. Mr. Vice President, we are introducing a piece of legislation that is going to give the judiciary certain powers to receive monies, public monies, electronically, and whether the monies come in the form of fees, Mr. Vice President, or fines, or what is called maintenance, or compensation. The AG has provided us with a list of the areas that would fall under the purview of this legislation, and he has given us data to support the current situation. Why would the Senate want to agree with the Attorney General when it comes to this particular provision? Mr. Vice President, I made mention of the Auditor General in this particular explanation as to the purpose of the Exchequer and Audit Act. So when you go to the Constitution, which the Attorney General referred to earlier, you will read under 116, subsection 2, the public accounts of Trinidad and Tobago and of all officers' courts and of all officers' courts and authorities of Trinidad and Tobago shall be audited and reported on annually by the Auditor General. And for that purpose, the Auditor General or any person authorized by him in that behalf shall have access to all books, records, returns, and other documents relating to those accounts. So under 116.1 of our Constitution, the Auditor General function and power is outlined. And Mr. Vice President, I want to go immediately to add to my point, Section 5 of the legislation, where we have under subsection 4 a provision that says custodial bank accounts shall be public accounts for the purposes of Section 116 of the Constitution. So if, for instance, Mr. Vice President, custodial bank accounts, which is being used to have monies paid into and out of these courts via fines, fees, or any other payment pursuant to an order of the court, rules of court, or any other law, which by its nature is revenue, how can the government bring a measure to have us oust, have us remove, have us excise, Mr. Vice President, the role of the Auditor General and the Exchequer and Audit Act? Mr. Vice President, the Exchequer and Audit Act would incorporate the Auditor General. It would incorporate the receipt, the issuance, and the payment of revenues. And the Attorney General is piloting a bill that is saying, Mr. Vice President, that in the event that there's a clash or a conflict between what he has now dubbed, the Honorable Attorney General that is, the payments into and out of court bill 2018, which one will reign supreme? Not the Audit and Exchequer Act, Mr. Vice President, but the payments into and out of court bill. Mr. Vice President, is the Attorney General serious? Is he serious? He cannot be. If we are talking about accountability, if we are talking about the management of public resources, if we are talking about, Mr. Vice President, given in this bill, as we have seen, the power to a number of persons, and I want to identify them for you in Clause 6, Court Executive Administrator, Deputy Court Executive Administrator, the Registrar, or the Chief Magistrate. 4 of them can sign along with any of the other that I'm about to mention. In Clause 6B, a Deputy Court Executive Administrator, a Deputy Registrar and Marshal, and it goes on, Mr. Vice President, to tell you the signatories to these accounts via the custodial bank account, or what is called the custodial, in fact, the custodial bank accounts, and we know that is coming through, Mr. Vice President, what is called a financial intermediary. So we are going to a bank, or I guess a bank in the first instance, they may go to, or they may choose to go to some other financial organization. So we are very, very worried and disturbed that you are given the power to two individuals. I cast no aspersions on anyone. I'm dealing with this thing in a generic way, and I'm dealing with the public interest and public monies. You have two individuals, Mr. Vice President, who are responsible for receiving and for issuing payments. So the same way you can receive and the same way you can issue payments is the same way, Mr. Vice President, you can, and I'm not saying it will happen, but you can have activities taking place in that arena that may leave a lot to be desired. And Mr. Vice President, what is the role of the Auditor General? The Auditor General has to go in there and check to ensure that the accounts of this particular custodial bank account is in a proper state consistent with the Exchequer and Audit Act. But if we are being told that in the event of a conflict, what does the Attorney General mean by this, Mr. Vice President? This is the language of his provision, of this provision, his amendment. In the event that there's a conflict, this act shall reign supreme over the Exchequer and Audit Act. Mr. Vice President, we on this side cannot, will not support any amendment that is going to oust or is going to excise or is going to remove the Auditor General and generally the Audit and Exchange Act in any conflict between that act and this particular piece of legislation. We will want to see that the Exchequer and Audit Act prevail and not the other way around. So that is an area, Mr. Vice President, that we are very concerned about, and we are not prepared to allow the Attorney General to have his way on this matter. Now, Mr. Vice President, when we looked at Clause 5(1), we see, for instance, there shall be established and maintained accounts to be known as custodial revenue bank accounts, which shall be held under the name of the Judiciary of Trinidad and Tobago at a financial intermediary in TNT to facilitate the payment into and out of court of fees, fines, and any other payment. Mr. Vice President, why is the Attorney General is afraid of the Auditor General? Why is the Attorney General and the government afraid of having the Exchequer and Audit Act supersede in the event of a conflict the current act or the current bill that we are dealing with? Mr. Vice President, I can only assume that there is something strange that is taking place. Mr. Vice President, I have looked at the Auditor General's report for 2015. I've looked at the Auditor General report for 2016. I've looked at the Auditor General's report for 2017 as it relates to the judiciary, Mr. Vice President, and accountability in terms of presenting their accounts and for the Auditor General to do a proper auditing of their accounts. And Mr. Vice President, I can tell you, if you go to the Auditor General report, the Auditor General's report for 2015, on page 23, you will see concerns being expressed by the Auditor General in 2015 about what, under the item or the heading trusts and other monies held, you'll see where the Auditor General is expressing his concern, Mr. Vice President. You will see on page 44, under the heading 03, Judiciary, the item is appropriation account. I quote from the Auditor General's report of 2015. There were 8 instances where the figures disclosed differed from those shown in 2.46 underlying records such as the vote book, abstract of payments, and schedule of accounts. And the Auditor General goes on, Mr. Vice President, to indicate that all is not well in the accounting and auditing of the books in this institution called the judiciary, Mr. Vice President. That was in 2015, Mr. Vice President, where you had a lot of variation in terms of contracts in the appropriation accounts, differing from the contract register by sometimes $1 million. In another instance, $1.6 million. In another instance, $1.7 million. Mr. Vice President, in the Auditor General's report on the judiciary, where we are being asked today that if a conflict develops between the Exchequer and Audit Act and this bill that we are dealing with, the Attorney General is telling us, allow this bill that we are dealing with to reign supreme, when the Auditor General is telling us that in 2015, there were no cabinet approvals for 21 properties totaling $16.9 million. That is what the Auditor General is saying. $21.974 million in 2015, Mr. Vice President. And Mr. Vice President, the Auditor General goes on in that said report to say rental payments amounting to $3.1 million were paid for one unoccupied property for the period 19th of August 2016 to the 6th of March 2018, and the building was only occupied with effect from the 7th of March 2018. So you want us to give you a blank check to allow the judiciary, and Mr. Vice President, as I said, I have nothing against the judiciary. I am dealing with public monies. I am dealing with public accountability. I am dealing with transparency. These are the items that I am concerned about and we are concerned about on this side of the Senate, Mr. Vice President. And if you have these reports emanating out of the Auditor General's report, how can an Attorney General bring such an outrageous amendment to this Parliament and say in the event that there's a conflict in this situation involving the Exchequer and Audit Act? Mr. Vice President, you know what is sad about it? The amendment did not speak about one element, of the Exchequer and Audit Act, It talks about the entire Exchequer and Audit Act. How can an Attorney General, want us to agree with that kind of arrangement? Mr. Vice President, another situation that developed, Mr. Vice President, in if I go, Mr. Vice President, to the judiciary again, in 2017, Mr. Vice President, or let's say I want to go to just 2016 to just bring you up to date. Mr. Vice President, would you believe that the number of accounts not submitted and valued by the judiciary in 2015 was 31, amounting to 7.473479.88. When I round it off, it is $7.5 million. 31 accounts were not submitted to the Auditor General, who is empowered under Section 116 to audit the accounts of the judiciary. Couldn't no account for 31? No answers, Mr. Vice President? And then, Mr. Vice President, when we come to 2016 accounts again, what are we seeing? There's something called vehicle control. Mr. Vice President, is it why we are being asked to give the judiciary a blank check so they can do whatever they want with public monies? Mr. Vice President, listen to this one. Vehicle control. Hear what the Auditor General said on page 30 of the 2016 Auditor General's report. A vehicle logbook as required for control of motor vehicle custody and maintenance for one vehicle did not record the dates of each journey. This is in violation of the Financial Circular number 16 dated the 20th of November. But that is not all. That is simple. Hear what we are being told by the Auditor General on that same page 30, 2016. 4 of the 6 vehicles examined bore no evidence of the official logo for identification as state property. Mr. Vice President, you understand what's going on? We are in Parliament. When we buy vehicles in the Parliament, Mr. Vice President, it has the Parliament logo. So wherever that van goes, wherever that car goes, Mr. Vice President, you have the official logo of the Parliament. In the case of the judiciary, we are being told by the Auditor General in 2016, 4 of 6 vehicles had no logo. So they are using public money to buy vehicles and do whatever they will. I am not accusing anybody of anything, Mr. Vice President. But, Mr. President, it sets your mind thinking. What could be happening with these 4 vehicles? Are they being used for private purposes? Are they being given to their friends? I don't know. I'm just asking questions because this is what the Auditor General is saying in his report. Mr. Vice President, I just want you to bear with me for one final report, which is the latest one that we got recently. It's the 2017 report. And Mr. Vice President, you have the same litany, same problems taking place, Mr. Vice President, in 2017. Again, a variation between contracts in the appropriation account and in the contract register, a difference of $1 million. In another instance, $1.6 million. In another instance, and $1.7 million, Mr. Vice President. So, Mr. Vice President, these are matters that we would like the Attorney General to pay attention to. Mr. Vice President, in 2017, we are told by the Auditor General that contract agreements between the judiciary and 12 contractors for projects totaling $1.2 million, and I'm rounding it, were not produced for audit. So, Mr. Vice President, if we are talking about accountability, and we are now going to a higher level of modernization by making payments electronically Mr. Vice President, don't you agree with me that there should be a greater degree of oversight and management over the use of monies that are issued and collected by this public body known as the judiciary, so that the Auditor General can properly audit those monies that are going into those bank accounts and coming out of those bank accounts? So, Mr. Vice President, if there is a conflict between the amount of money that went into this particular custodial bank account and those that came out of it, and the Auditor General is auditing it, and the difference is $4 million, the Attorney General is telling this Parliament that wherever a conflict exists, this bill that we are debating, Mr. Vice President, must take precedent, must reign supreme. Mr. Vice President, we cannot support such a measure that is being suggested by the Attorney General, Mr. Vice President. Mr. President, I want to ask another question, Mr. Vice President. You go to part 3 of this bill, Mr. Vice President, and you go to section 15. You go to subsection 1, A and B respectively. Mr. Vice President, no one can argue and nobody will have a fight over convenience, as I said earlier. But I have, like the Attorney General, we received a copy on the judiciary website of a practice direction. We have a practice direction we got from the website of the judiciary, and it is signed. In fact, let me tell you what's the heading, Mr. Vice President. Court pay system for the payment in and out of court of maintenance payments by electronic data transfer. It is signed by the Honorable Chief Justice, Mr. Ivor Archie, and it is dated the 18th day of May 2018. There is a schedule attached to this document. This is consistent with the CPR rules, where once you issue a practice direction and this bill is passed, you have to gazette it, and then it becomes, once it gets gazetted, legal notice follows, and you get an instrument coming to this Parliament through the legal notice. It goes to the Statutory Instruments Committee, and we have 40 days as a Parliament to determine if you are going to bring a motion to have this matter annulled. And well, so we are waiting to see what will emerge, Mr. Vice President. But Mr. Vice President, what I want to go to is the schedule. This was signed on the 18th of May 2018. We are debating a matter on the 11th of September. May, June, July, August, September, almost about 5 months later, or just under 5 months. Mr. Vice President, you know what we understand to be taking place? This system where you are charging people a transaction fee. As I said, Mr. Vice President, I have no problem with that. If you have to pay maintenance, and rather than you leave Tobago, not you personally, somebody else from Tobago, to come here into the courts and pay, it's better if you go and top up and send your money electronically. I have no problem with that. That's an easy way of doing business. It's a convenience. But, Mr. President, the question that we are asking is this, and I hope that the Attorney General will be able to help us. One, this, Mr. Vice President, may I tell you, may I ask you to follow me here? The cost of this whole transaction, if paid into the recipient's bank account, it is $4. If it is paid into your bank account, you pay $4 as a transaction fee. If paid into the court pay merchant in enabled paid out card, you pay $6, Mr. Vice President. And if paid into the court pay closed loop pay out card, you pay $5, Mr. Vice President. I want to ask the Attorney General through you. When this $5 and $4 and $6 are paid, where is that money going to, Mr. Vice President? And what percentage of that money is going to the owner of the software? And what percentage is going to the government through the courts? Because, Mr. Vice President, you cannot tell me that I am paying $6 to have this thing transacted, so I don't have to come to Port of Spain because I'm from Mayaro. And the $5 or $6, if someone is the owner of the software, it's going to the person $6. I want to ask the Attorney General, explain to Trinidad and Tobago today, where is that $6 going? Where is this $5 going? Where is the $4 going? Is it going directly into the account of the private owner of the software, or is a percentage going to the owner and a percentage going to the government? Mr. Vice President, these are serious matters. Mr. Vice President, you know what happens when you don't have systems of accountability. Mr. Vice President, you know what happens when you don't have proper checks and balances. Mr. Vice President, when you don't have proper systems in place, money is a temptation, and people will put their hands on money. And you must have systems in place to ensure that there is proper accountability, and the institution that we have established under our Constitution to ensure that there is proper auditing and accountability of public monies is the Auditor General. And that is under the Exchequer and Audit Act, which we are being told that must be ousted. Mr. Vice President, I want to ask another question. Is this Senate a rubber stamp? Is this Senate, the PNM government, rubber stamp? My information, our information, Mr. Vice President, is that the system that we are debating today is already in effect.
So you have 5 more minutes.
Mr. Vice President, I am putting to you and this Honorable Senate, Mr. Vice President, that the system that we are debating today is already in effect. The question that we have to ask ourselves is the legality of that system. The Attorney General must tell this country whether he gave approval to the judiciary to begin effecting this measure before it came to this Parliament for formal approval or for approval. What is the role of the Attorney General in this whole transaction? I'm asking you whether you advise the Chief Justice to proceed with this measure in the absence of parliamentary approval. That's the question I'm asking you. And we are saying on the opposition benches today that this is an illegal action, an illegal measure, and we cannot support illegality that the Attorney General is presenting here today. And that is why, Mr. Vice President, I accuse the Attorney General today, in no uncertain terms, of bringing a bill, Mr. Vice President, bringing a bill today. And when I say accuse him, I mean in any kind of negative way. Right, Mr. Vice President? I want to apologize if you get that right. But I am just saying, Mr. Vice President, I'm sorry about that. I apologize. Right? Mr. Vice President, I want to tell you, I am telling you, Mr. Vice President, the reason why we are being bombarded with 33 amendments today and 2 new clauses and telling us we must only take 15 minutes to absorb that and to digest that is because the government of Trinidad and Tobago is trying to hoodwink the parliament. The government is trying to hoodwink the parliament and allow us to pass legislation that is poor, that is weak, that is inadequate, that is going to bring harm, Mr. Vice President, to the people. And we stand for the public good. We stand for the public good, and we will not support any measure brought by the Attorney General and the government of Trinidad and Tobago that will weaken public accountability and weaken public management and weaken our institutions in our country, Mr. Vice President. We will not do that.
Why didn't leave this for something else?
We will not do that. And therefore, Mr. Vice President, we put the Attorney General on notice. Come clean. Tell the country the truth.
Or else.
Let us know what is behind this illegality. Let us know, Mr. Vice President, whether you are aware, when I say you, the Honorable Attorney General is aware that this system is in operation, and it has been in operation for the last 2 to 3 to 4 months. And they are collecting money illegally from the public. Illegally from the public. And they do not have the sanction of the parliament. Hence the reason he wants us, that is the government, the Attorney General, to oust the Exchequer and Audit Act that will be able to go in there and do the auditing and accountability and discover all the mess that they have created. We can't support that, Mr. Vice President, please. We can't. Can't support that. So, Mr. Vice President, we have looked at what the Attorney General has brought. We believe that on the face of it, there's no problem with convenience. But when we drill further down, Mr. Vice President, we are seeing a lot of problems, concerns, and challenges facing the nation based on what the Attorney General is attempting to do today. We cannot, in good conscience, support this measure in its current form. In those circumstances, we intend to propose a series of amendments for the Attorney General's consideration, and if the Attorney General is minded to support us, we will reconsider our position. If he does not support us, I give him notice now that we will not support this legislation in its current form. It is unacceptable, and it is not in the national interest of Trinidad and Tobago. And we stand for the national interest, and we stand for the people's interest, and we will continue to advocate a society and a parliament that is based on transparency, on accountability, on openness, Mr. Vice President, and on probity. We are not for secrecy. Thank you, Mr. Vice President.
Yeah. Senator Chote.
Thank you, Mr. Vice President, for the opportunity to contribute to this debate. I must say I would have liked to have had a look at the amendments if they had been sent electronically. Perhaps that would have given me a little more time to look at the issues which are raised, because there are many proposed changes to the gazetted document which we had received a few months ago. But I will do the best that I can. Before I go into the substance of my contribution, I would like to, on the record, offer an apology for a statement I had made on the 21st of June 2018, where I had said, because that is where my research had taken me, that the Auditor General had said that since 2014, there had been no accounts produced by the judiciary. I received some correspondence by a protocol officer from the judiciary who said that my comment was dangerous and asked for it to be corrected. I pointed out that I couldn't do so until I corrected it while speaking. So I am correcting that. The Auditor General has received financial statements and financial information from the judiciary up till 2017. However, there were many individual areas of concern with respect to expenditure control, rent, lease, office accommodation, storage, and the rental of unoccupied property, reflected in the Auditor General's report for 2017, which was the latest. So I correct it and I add this to my correction. I believe that if we look at other reports from the Auditor General, there may have been comments about the handling of trust funds and whether they had been dealt with at all in terms of the provision of financial information. Now, I just inquire about that because what we are looking at here is legislation which will be operating as a trust fund, or so it seems. So I think if we are putting in place something which is going to operate as a trust fund, then we need to be sure that there is everything put in place for well, I can't say transparency with trusts, but certainly for accountability. Because at the end of the day, the money is paid into these accounts will be affecting the lives of citizens, not only in terms of their family lives, but in terms of monies confiscated under the Proceeds of Crime Act. It may affect monies, cash bail monies paid in, and which will have to be paid back out. It will affect maintenance fees. It will affect fines imposed by persons for criminal offenses, and all of those different aspects of the law. Now, I want to jump ahead a bit by saying that I found it a little difficult why we had to understand why we had to have a separate piece of legislation to do this. Because in my quick read of the Exchequer and Audit Act, it seems to me that what is wanted, what is required to be done, can possibly be done under the ambit and purview of that act, which already has systems for accountability and so on. So I don't know why we've set that act aside. And if we felt that it wasn't a good fit, then it could simply have been a case of making the necessary amendments to that act. So we would have had the security of knowledge that there were the financial controls which apply to that act and everything it covers to this system which is now being introduced. So I don't know the reason for us going outside of the Exchequer and Audit Act, but I also do have a great deal of concern about the clause which proposes that where there is an inconsistency between the Exchequer and Audit Act, that inconsistency will be resolved in favor of this act. The reason I have so much concern is because the Auditor General, to whom the judiciary must account, is created and gets his powers from the Exchequer and Audit Act. So I don't know what that clause was intended to cover, and whether possibly there is a potential for this legislation to somehow avoid the scrutiny of the Auditor General's office. I don't know. I say that I can only throw it out. Had I received these amendments in a more timely fashion, certainly I may have been able to elaborate some more. But as I say, I'm doing the best that I can. I am not a speed reader, although I did try to reference the relevant legislation as quickly as I could. Now, let me jump ahead a bit, because this is part of it which concerns me a great deal. In Section 14.2, there is a new proposed subsection, Section 14.2. The court executor, sorry, I beg your pardon. Section 15, the Rules Committee established under Section 77 of the Supreme Court of Judicature Act may make rules of court providing for the payment of any convenience fee, transaction fee, or other fee in relation to payments into and out of court or a custodial bank account and for carrying into effect the provisions of this Act. Seems perfectly innocent, doesn't it? Because the Supreme Court of Judicature Act allows for these kinds of practice directions to be made for operational issues. But what has me gravely concerned is the fact that there was a practice direction in May of 2018, before this legislation came into force, and more importantly, there was an entire procedure set out and placed on the judiciary website telling you how court pay was going to be regulated, and more importantly, how you were going to be regulated by court pay. It is, just a second, it was, what am I doing here? It was referred to as court pay facts, and this is what the public was being informed about. Now, how can the public be informed about a procedure which regulates the collection and payment of public monies? Because if it's under a court order, it's public money, when there have been no rules made to regulate it. By what authority did court pay and those associated with court pay decide that they were going to create these rules for the regulation of public funds and have this put up on the judiciary website? Now, I find this quite astounding. But that is just me. Perhaps I tend to find things astounding. I'm sure there must be some sort of logical answer for all of this. It must be something that I overlooked. And I'm sure that it's very dangerous to overlook things like these. That is to say, the absence of laws, but the creation of regulations to govern public money. Now, I'll tell you why I was scared. Customer service and support. What is court pay? And I'm reading from the document on the judiciary website. It is an online or electronic method of making court-ordered maintenance payments, because this had initially been introduced for maintenance payments. Now, electronic maintenance payments is a great idea. If we had internet in all of the courts, it would be a wonderful idea. Is court pay mandatory? Answer: court pay is mandatory if the court orders it. Now, where in the law did court pay have the power or the right to say what a court could order and what would be mandatory upon such a court order? Now, this is being put out to members of the public as if this is the law. This is how the system is going to operate for the collection of public monies. And this is how it's going to be accounted for. And there was absolutely no law in place to do that. Where can I access more information on court pay? Judiciary's website, www.ttlawcourts.org, the court pay Facebook page, information fact sheets and FAQ brochures at the family court. Security, what are the terms and conditions for using the court pay account? Terms and conditions of use can be found on the website. They don't tell you. Do I need a password? Yes, a default password will be issued when you register. However, we strongly recommend that you change your password immediately. There's no expiry date on your password. They tell you how to get a new password. How do I know that my banking information will remain confidential and safe? Your personal information, including your username, password, and other sensitive information, is transmitted over a secure channel via Secure File Transfer Protocol, SFTP technology. I have no idea at all what that means, and encrypted into our database on a secure server. Do I need a bank account to register for court pay? If you are the payer, you can access the service without the bank account, and so on. If you are the recipient, the payee, you do not have to have a bank account. I'm summarizing here. Can I register for court pay after the court date? It must be made on the basis of a court order. So you have to wait for the court hearing for such an order to be made. What happens if a person is unable to sign their name at registration? The appropriate attestation methods will be applied for that purpose. Now, this is simply bizarre because you have somebody who can't sign their names, but you are asking them to use an information technology process, an electronic system where presumably they will have to read a screen. And they will have to check receipts to make sure that the receipt reflects the transaction accurately. Now, let me see, it goes down. There are many, many questions and answers. Let me take us to some of the more important ones. General questions on payments and fees. Now, I thought this answer was particularly interesting to this question. Can I still pay my maintenance fees at the counter? Answer. You must comply with the court's order. Once the court orders that monies be paid and received using the court pay system, these instructions must be complied with. What are the payment options? Payment options are cash top-up, credit card online payments, credit card at a court pay enabled kiosk TT Connect, links at a court enabled, well, that's just a comma there, direct debit from your bank account. Fees applicable. A transaction fee is applied to each transaction the payer undertakes. A list of transaction fees and costs is listed in the attached schedule of fees and costs and can be obtained at the court office or the judiciary's website. I pause to say that that appears to be the same list of transaction fees which we were provided with this morning by the Honorable Attorney General. I thank him for it, but unfortunately it didn't include all that went before. Let's see. Do I need user interface? Do I need a computer to use court pay? Court pay is an online system. Therefore, to use court pay, you must have access to the internet using a computer, smartphone, or tablet. And if you don't have a computer, smartphone, or tablet, you can use a kiosk or self-serve desktop, which is available at any court-enabled location or TT Connect. Now, most of our courts do not have an internet service. Let's see, electronic debit to the payer. Can I arrange to debit any type of account? Yes. But it doesn't include credit unions, unit trust, or any account not held by a commercial bank, and so on and so forth. And then they go on to say what happens if the date of payment falls on a weekend, if your pay comes into the account late, and that kind of thing. But what I thought was very interesting is this. It seems as though, under the rubric electronic credit to your pay card, in brackets, payee stroke receiver, close brackets, what is a Republic Pay card? The Republic Pay card is a reloadable Electron Visa stored value card issued by the bank. Only payments ordered by the court to be paid into court can be made to the pay card, and only those court-ordered funds can be accessed by the pay card. What do I need to obtain a Republic Pay card? So it seems as though a decision has already been taken for Republic Bank to do some, well, I can't say all of the transactions because I didn't have time to read all of it, but some of it certainly. Now, terms and conditions, because with banks I always like to know that. What are the terms and conditions for using the pay card? You will receive official terms and conditions which you will be required to sign when applying for the card. So there is really no question of having a look at the terms and conditions before you apply for the card. And so on and so forth. Can a pay card be skimmed? Yes. Any card can be skimmed if you are not careful. You must take all precautions to safeguard your pay card and its use as you would any other bank card. Let's see. And if your card is lost and stolen and so on, there are procedures for that. And they talk about the activation of the card and that kind of thing. So with all due respect, having regard to the great detail which has been set out in this information electronic manual, if we want to call it that, and posted up officially on the judiciary's website, it would seem that when we come here and we are asked to vote for a piece of legislation which tells us in section 15 that the Rules Committee will be making rules providing for the payment of any fee and transaction fee and payments in relation to payments in and out of court and for carrying into effect the provisions of this act, that these rules have already been made. That we are being asked to rubber stamp a process which is already in existence. Now, I don't think that's appropriate, and I will leave that there. Now, the reason I want to go back a bit. The reason I had said earlier that I thought the appropriate thing to do was to use the powers under the Exchequer and Audit Act to achieve what you want to achieve in this piece of legislation is because even though this act was enacted in 1959 and the Honorable Attorney General made heavy weather of that, it's been amended 40 times, 40. And the last amendment was in 2014. One of the amendments, one of the more recent amendments, is to be found in Part 4A, Section 23A1, which says that notwithstanding any other written law, a payment into or issue out of A, the Exchequer account, or B, other public monies, howsoever held, may be by means of electric funds transfer in accordance with general or specific directions issued by the Treasury be made, or words to that effect. So it means, to my simple mind, that there may be a power already residing within that act that we could use to effect what we want to do, because that's a good thing. We don't want to make the law more complicated by having legislation which contradicts, which confuses, and which, with all due respect, misleads. The Exchequer and Audit Act also provides in Section 23B1 that the Minister of Finance, because that's the minister in charge of public funds, as far as I understand, even though the judiciary has control over its own funds, at the end of the day, it's state funds. So the person ultimately responsible is the Minister of Finance. The minister may make regulations to give effect to the provisions of the Act. So the Minister of Finance, even if we don't want to amend the terms of the Exchequer Act, the Minister of Finance, it seems to me, has a lot of power under this piece of legislation to make regulations to deal with different kinds of transactions. So this is what I thought we could look at. Now, I am a little concerned because I thought the Honorable Attorney General, as we say as lawyers, is the titular head of the private bar. And I, as I stand here as an independent senator, I am also a member of the Law Association of Trinidad and Tobago, because that is how we are able to practice. We have to be members of this regulatory body. So I was quite concerned when it appeared as though there was some dissonance in views between what the Law Association was saying and what the Honorable Attorney General was advancing. And when I looked at it, I really could not find the reason for the heat and fury, let me put it that way, because I saw what the Honorable President, Mr. Douglas Mendez, Senior Counsel, had said, head of Senator Roach's chambers. And what he had simply said is that insufficient attention had been paid to that very act which I've spoken about, the Exchequer and Audit Act, when this piece of legislation had been proposed. Essentially, that was it. And the concerns were not that the Law Association was against electronic payments or the Law Association was against advancement. Who isn't in favor of advancement? We all are. What the Law Association was saying is that as lawyers, we have a duty to see that if monies are being collected within the justice system, that it's collected on a lawful basis, one. So as it is, a magistrate has the power to make a maintenance order, let's say. The magistrate doesn't at the moment have the power to make a maintenance order and attach onto it a transaction fee. But this is what was being proposed. So the Law Association was saying, well, you may have to amend a few other pieces of legislation as well if you want to make this thing work. So I would like us, if I may respectfully suggest as senators, for us to put aside the heat and fury. At the end of the day, the Law Association is an important body in civic life, but the Law Association is not in this Senate. So I don't know why we were required to listen to 15 minutes of what the Law Association did or didn't do. I think at the end of the day, we can find that information out and address it as we see fit. I would really like it if we can focus on the piece of legislation which is before us and its relationship with that other very important piece of legislation, the Exchequer and Audit Act. I think we need to have some sort of analysis and comparison of these two pieces of legislation to determine how we are to approach the legislation which is before us today. In addition to which, we cannot close our eyes to the court pay information and the practice direction, because it means to say that something may already have begun without a basis in law. And that puts us in a very difficult position because we are being asked to pass law in a way after the fact. It's not called practice directions at this point in time. It's not called rules of court at this point in time. But there clearly already is a system in place right down to the provider for the transactions. So that leaves me with a big question mark. In fact, it leaves me with many question marks. And I wish that some time had been spent in telling us, well, listen, this is what happened. This is how we set about trying to accomplish what we wanted to do. Perhaps it didn't work out, and this is why the legislation is necessary, and this is why we had to bring before you this morning an amended version based on input from other people. I think certainly that may have got us to where we wanted to be in terms of understanding why we need this legislation at all, and secondly, understanding why this legislation now has to take priority over the Exchequer and Audit Act. Because I don't think any proper explanation has been given or advanced for that particular clause. So, Mr. Vice President, I think I have encapsulated all that I would like to share with the Honorable Senate on these issues this afternoon. And I think I want to stress that my presentation is not a criticism of the Honorable Attorney General. It is a request, a plea. I won't say a request, it's more of a plea for clarification. And perhaps I haven't had the clarification that I may have got had I had more time to look at the amended version. But certainly, I would be grateful if the Honorable Attorney General would condescend to provide some clarification on some of the issues which I have sought to bring to the attention of the Senate. Thank you very much.
Minister in the Ministry of Finance.
Thank you, Mr. Vice President. I rise to support the bill that is before the House on the introduction of electronic payments into the court system. Mr. Vice President, we are in 2018, well into the 21st century, and electronic payments are a way of the world. What the judiciary is now, what the government is now seeking to do is have the judiciary catch up with the rest of the world in heading in that direction. And there are several reasons for that, Mr. Vice President. If we look at what the bill is seeking to do, it is seeking to allow for payments to be made into the court to be made electronically. We're dealing with maintenance payments, fees payable into the court, fines payable by law, and other payments payable to the court by order, laws, or rules of the court. And the reason for that is there's a significant mischief with the current system which we are seeking to address and to correct. Now, if we look at what transpires now, we can identify, and the public can identify what the mischief is. So let's look at it in the context of maintenance payments, which the public is most familiar with. the court gives an order for maintenance payments. What happens now is that the payer, usually the husband or the male in the relationship, has to go into the court where the order was made to make the payment. If the recipient of the payment, usually the wife, would have to go into the court to collect the payment. So, from the payer's perspective, let's assume the payer and his wife at the time lived in Point Fortin. Order is made by the court in Point Fortin. The payer is then transferred because of his job, or because of a new relationship, or because of a change in circumstances to Roxborough. And he has to make a weekly payment to the court. What is required now is that he must travel from Roxborough once a week to the court in Point Fortin and make a payment to the court, usually in cash. His ex-wife or separated wife will then also have to travel from, let's say she's now living in Diego Martin, to the court in Point Fortin to collect this maintenance payment once a week, usually in cash. If the payer does not make the payment on the due date and the wife goes prior to the payment being made, she will have to go back on another occasion. What problems does that give rise to? Significant inconvenience, because people have to take time off from work, they have to travel long distances potentially. It is risky because they have to walk around with different amounts of cash. It is uncertain. The wives may have to take time off. They may have to find somebody to take care of the child while he or she is away. It may cause several delays, several days. If the cashier did not turn out to work on the day that either the payer or the payee is going to pay or receive the payment, nothing can be done. You have to walk around with lots of cash. It is risky in today's world of high crime. I have been told that depending on the volume of activity in any court in a particular day, that the transaction of either paying or receiving the money can take up to 3 hours. Let's look at it from the court's perspective. The court it's a labor-intensive operation. Somebody has to record the receipt of cash, has to record the payment out of cash, has to, more importantly, receive this cash and maintain the cash on site so that it is available when it is to be collected by the recipient. I have been advised by the registrar that it is not unheard of for a cashier to have $1 million in cash in her drawer on a particular day. I have been reliably advised that this has in fact happened. And Mr. Vice President, this creates a significant security risk, as you would appreciate. And we're not talking necessarily about the Hall of Justice, where, at least it's in the middle of Port-of-Spain, and police stations are not too far away. We're talking about court in Siparia, a court in Point Fortin, that does not have the wherewithal, the security, the infrastructure to deal with this kind of risk and to handle it properly. Also, Mr. Vice President, we have two sets of payments here. We have payments that the court collects on behalf of other people. So in a maintenance situation, the court should be collecting funds to pay to the recipient of those maintenance payments. And we have public monies, fines and fees and so on. The money that is collected to pay over to other people, the court has to retain in its possession so it's available for payment, as I just said. The money that is to be paid, the money that is public money, has to be paid into the exchequer. And what currently happens, the practice currently, is that when these monies are collected in regional courts, they are transferred to the Inland Revenue Division. even the Inland Revenue Division, which has been set up to collect public funds, and therefore one assumes has proper security and proper facilities in place to do that, has recently started demanding of the courts that it transfer transfer amounts that are significant into a bank rather than into the Inland Revenue, because we all would have known, if we're reading the newspapers, that the Inland Revenue has been the subject of the victim of theft twice within the last year or so. The branch, the outlet in Chagonas and the outlet, I believe, in Sangre Grande have both been attacked. Their vaults have been seized and money has been stolen. So Inland Revenue, that vital link in the connection between the court and the exchequer for the collection of large sums of money, is now resisting the practice that has been in place to take these funds to accept these funds from the court and transfer them to the exchequer, because they recognize a level of risk. So, Mr. Vice President, this is what happens now. What the system that we are seeking to introduce is to allow the individuals the option, unless the court chooses otherwise and imposes an obligation, as and when the court has that authority, it gives them the option to pay the amounts due electronically. And they have various options various ways in which they can do that. They can do that using an ATM card. They can do that using a credit card. They can use the lotto booths. Now, one of the things that Senator Chote would have commented on was, how is somebody who is, I guess, among the vulnerable or among the less educated and therefore not being able to properly read and deal with computer programs and so on, how is he or she to take advantage of this system? I doubt there are too many people in Trinidad and Tobago who cannot easily access and take advantage of the services offered by the people who have been operating Playway in Trinidad and Tobago for the last how many decades. So the lotto booth is there. People top up with phones. People purchase Playway tickets on a daily basis. So they have a level of comfort with at least that option under the whole process of electronic payment. So if they're not comfortable going online, they can go to the lotto booth and get their payments facilitated that way. What does this do? It makes the payment more convenient, much more convenient, because you can sit down in your Scarborough home or in your Roxborough office and make the payment even in respect of an order that was issued by a point fortune court. The recipient of the payment, who is residing in Diego Martin, no longer has to go to that point fortune court to collect his or her money. She can get it from her account using an ATM card. It reduces the level of staffing that need to be allocated for the purpose of collection of funds, because a lot of the work is being done electronically. I have had the advantage, I would think, of meeting with the providers of this service. And I am comfortable that the service is set up in such a way that not only does it facilitate the payment, but it reconciles the payment, it keeps a record of the payments so that it is easy to track, it is easy to follow, and most important, based on a lot of comments made on the other side, it is easy to audit. Because as the Attorney General would have said in his opening comments, we are not talking about introducing new payments. We are not talking about imposing obligations on persons in Trinidad and Tobago that did not exist before. People are making maintenance payments. They're making payments of fines. They're paying fees to the court. They're making payments under orders. All these things are going on now. The difference is that we will give the other side, the persons involved, an option to not do this in cash. That is the only difference. And what does that do? The Auditor General currently has an obligation and a right to audit the payments received. But when he goes into the court, he may find that the physical record book in which the payment was recorded cannot be found, or that a page is missing, or that it cannot be read because it probably wasn't written, or that the clerk who took down the information took it down incorrectly, either deliberately or not. That is what he finds now. When you switch to an electronic system, there's an electronic record of that transaction. It is more difficult to misrepresent transactions when they have to be done electronically. It is more difficult to cause electronic records to disappear. What the legislation does, which was not mentioned at Section 10, is that not only Section 10(1) of the draft bill, not only does it recognize the Auditor General's continuing right to audit these transactions, but it specifies that he is entitled in the process of the audit to access to the electronic records. And electronic records, as I am of the clear view, that electronic records tend to be superior to physical records. The chance for inaccuracy is reduced, the chance for loss of records is reduced, the chance for the trail of the transaction disappearing is reduced. So in my view, we are not compromising the Auditor General's role in this process. We are enhancing his ability to do his job. Senator Mark would have commented on the Section 5, and Senator Chote as well, that the legislation seeks to give precedent to the bill when there's a conflict between the bill and the Audit and Exchequer Act. Now, although we have had comments from both of those speakers on the issue, neither one of them was able to give any example of where such a conflict would exist and what their concern was with respect to giving the bill precedence. That's one point. Secondly, although I haven't practiced before the courts of Trinidad and Tobago in decades, and since I have stopped practicing, my focus has mainly been in civil law and tax, my recollection of a basic tenet in law is that legislation that comes later supersedes legislation that was previous if there is a conflict. That's my recollection. So my interpretation of Section 5(1) is that it is documenting, concretizing something that would exist in any event. But the Attorney General will deal more comprehensively with that issue. Comments were also made in terms of the individuals who have the right and responsibility in respect of the accounts that will be created to deal with these transactions. Again, we are talking about people who now have responsibility to deal with monies that are collected by the court. We are not giving them any additional rights to which they are now not entitled. These people are now responsible for collecting, maintaining, accounting for, and protecting millions of dollars in cash. I remember when I mentioned earlier that I was told that it was not unheard of to have $1 million in a drawer in a clerk's desk. Let me give you some examples of the kinds of money that the courts collect. And as I speak, I am loath to do this because I feel as though I am communicating to the potential miscreants out there that this is an opportunity that they may have missed. But fines collected by the court during 2016 to 2017, the Magistrates Court, $29 million. Fees, $345,000. 2016 to 2017, Superior Courts, $235,000. Fees for the Superior Courts, $1.9 million. In 2015 to 2016, the total fees collected by magistrates and Superior Court, $27.3 million. Total fines, the fees were 2.4. Fines collected in 14 to 15, 24.7 million. Fees, 2.2 million. And so on. So in looking at maintenance now, which is another significant area, maintenance amounts collected and retained for passing on to the recipients of those maintenance payments in 2016 to 2017 totaled $119 million.
Wow, collected.
1 year. So is it unreasonable in those circumstances to think that on any particular day you could find up to $1 million in somebody's drawer? No, it's not. Because we're talking a significant amount of money. And that money in particular, the maintenance money, the money that is collected that goes to the exchequer is collected and deposited on the same day. So moving the money around is risky, but the risk is short term. The maintenance money has to be kept on the compound. Yes. The maintenance money has to be kept on the compound so that when the recipient of the money comes in, it's easily available. Is this a system we want to continue, Mr. Vice President? I would think not. I would think everybody would be promoting that in 2018. It's obscene that we are operating a system like this. So, as I said, I am concerned about the fact that we are not more enthusiastically embracing this bill. So, under the proposed system, the people who are signing, the people who concern us now, who may be up to mischief, can be up to more mischief now, because they have in a drawer cash, and they have a written record that can disappear what was collected and what was paid out. When we move to the new system, we will have an electronic record, which is more difficult to deal with. And in addition to that, these monies are no longer coming into these monies are no longer coming into the hands of the court clerks and the cashiers. They are going to a bank. Sure.
I'm just confused based on what Senator Chote, and thank you for giving me, would have elucidated from the court, the judiciary website. Is this system in operation already? And if so, why are we saying when it comes into play? Thank you.
Sure. Okay, so as I indicated earlier, Senator, through you, Mr. Vice President, there are two categories of monies. There's money that is collected on behalf of other people, mainly the maintenance money, and there's money that is collected on behalf of the government of Trinidad and Tobago. In April of this year, the court introduced, on an optional basis, the payment of maintenance payments electronically. So it is not currently authorized to, nor is it seeking to collect public monies through this system, because it does need the authority of the Parliament to do that, which it doesn't currently have. But it is saying to people who are entitled under court orders to maintenance payments that you can, at your own option, choose to pay this and receive this electronically. And that is what has been introduced. So, right, I was saying that the public monies that are intended to go to the coffers are received in cash, transferred to a bank, and then transferred to the Treasury. That happens within a day. The maintenance monies are retained until the people entitled to them come forward. What will happen going forward is that these cash payments will no longer need to be received by the courts. They can be deposited straight into a bank via the various electronic means. That reduces the risk. It makes following the transaction clearer. The record of the transaction is more certain, and it is quicker because you no longer have to find time to travel to the court to get the money. You no longer have to wait for the clerk to record the thing and be able to pull it up and find it. Within hours of the money being transferred, it hits your account and you have access. So it is efficient, it is safer, it is more secure, it requires less physical resources. And in 2018, when everybody in the world has gone electronic, I don't see the basis for objecting to this approach. As I said, the role of the Auditor General is not being reduced, not being compromised. We recognize the Auditor General has a very important role. What we are doing is saying to him that in addition to the physical records that you're usually accustomed to, you will have access to electronic records, which, as I said, are usually more dependable and more secure and have a longer life so that you can come in. Not only that, in meeting with the individuals who have developed the system, what was clear to me, as I said, is that the system is self-regulating. It records the transaction from payment through receipt, so that, and it reconciles itself and the payments daily. So at the end of the day, not only the courts, but the bank and the Treasury know what has been collected in each account. So they don't have to wait for the court to send a record to say this is what happened. It is electronically updated so that they know what's happening, they know what to expect. So if the money in the bank does not reconcile with the system, then they can ask questions. At the moment, they may not have that opportunity, they may not have the knowledge, because what goes into the bank could be doctored to agree with the records. Whereas if you have an electronic system that is separately dealing with that, as third parties pay money and third parties receive money, it is more difficult to doctor the records. So it makes life, in my view, much easier for the Auditor General than he currently has it. I'm also concerned about confused more than concerned about the comments made about how the judiciary can manipulate the system, because it is coming from a place and from individuals who have said to this Parliament, unless I am mistaken and over the holidays I forgot, that we should move swiftly towards giving the judiciary autonomy. So either you think they're responsible enough to have autonomy and be responsible for their own money and their affairs, or you don't. So we can't be fish and fowl. Thank you, Senator. The fees, where are the fees going? In any electronic transaction, we have to recognize that they're service providers. The service providers will be, based on the systems that we are using, the banks. And the reason why Republic Bank is the bank that is represented, Senator, is because they're the ones to date who have taken up the challenge of getting involved in this transaction. The government is open. The government is open to dealing with any bank that is prepared to engage and to facilitate what we are seeking to do. Republic Bank at the moment, notwithstanding the existence of senators in this place that may or may not have past associations with the bank, are the ones who have said to date, we are happy to engage in this transaction. So that is the only reason we are hopeful that The First Citizens Bank will come on board shortly, and all other banks who are willing to get involved at the kinds of reduced fees that we have been successful in negotiating with the bank, happy to invite them in, because it just makes the system that much more accessible to all the population, and especially the people who are most vulnerable. That is our sole objective. They were all invited, yes. So where we are is that we are seeking to introduce a system that is simple, that people are used to because of their day-to-day activity. As I said, they top up their phones all the time. They go to lotto booths all the time. They use the ATM all the time. And fewer, but many, use credit cards all the time. People are used to these things. They are simpler. The level of security that that attaches to the system. Senator Chote used an acronym which she didn't understand, and I don't understand what it means either. But what I understand it to be is that it provides the same level of security that is provided in respect of credit card transactions. That is what I have been advised that means. So the level of security is high. It is something that we have given people options in terms of how to use the system, or what aspects of the system they wish to use. We have made the system of payment into and receipt of payments out of the court more efficient. The money gets to the exchequer quicker. There is a system of reconciliation. There's a system of record. The Auditor General has easy access to the record and can properly audit and follow these transactions. In those circumstances, it is difficult for me to conceive of a basis why anybody would not want to support this bill.
And I'm grateful that I have the opportunity to ask this question during your contribution, but how will it work? Because the Auditor General can only audit government or state-related institutions. How will it be able to access the records of private banking institutions? I don't follow that.
No, okay. The transaction is a court transaction. The bank is facilitating the court transaction, so it is not. The Auditor General is not auditing the bank. It is auditing the transaction, which is facilitated by the bank. The court will have its records. The Treasury will have its records. And the transaction will show the flow through the bank from the court to the Treasury and vice versa. So that is the basis on which the Auditor General will.
If there's a discrepancy about what has been put in at the bank or what has been taken from the bank, the primary source of information will be the bank. And I'm not following how that will be managed. If the financial uncertainty arises with the bank records, how will the Auditor General be able to find out, well, what occurred, if anything?
Well, as an account holder, which is what the court will be, they will be entitled to secure the records in relation to those transactions from the bank. So it would seem to me that that would facilitate the access of the Auditor General to those accounts. Yes? So, as I was saying, in my view, this system is something that is long overdue. It has been well thought out. It has been employed to date with respect to non-public money transactions. It has worked well. The users of the system are commending the system and are happy to use it. I don't see the challenge with the issues that have been raised so far with respect, and in the circumstances, I recommend the bill to my colleagues. Mr. Vice President, I thank you.
Senator Ramdeen.
Mr. Vice President, thank you for the opportunity to contribute to this debate this afternoon. on this piece of legislation that on the face of it looks very simple, but has very far-reaching consequences. And I hope that my contribution this afternoon, Mr. Vice President, would be able to enlighten the members of the Senate to understand the seriousness of the decision that we are being asked to take here by the passage of this piece of legislation. Now, Mr. Vice President, I want to start off by trying to put a dose of reality into this bill. And before I actually get into that dose of reality, I think this bill is a perfect opportunity for the people of Trinidad and Tobago to understand the disconnect that this government has with the people on the ground. Because this particular piece of legislation is a piece of legislation that has been advanced on the basis that is ease of payment. That is what this is about. And you know what I take great umbrage of in the way this piece of legislation has been piloted is that it has been piloted in such a way that it gives the impression to the public that this is going to give some kind of relief to people who have to make these payments into court and who have to receive payments from court. But if anyone understands what happens in rural communities in this country, in rural courts, like in Rio Claro, Mayaro, Sandy Grande, Point Fortin, Hoover, what happens in those courts? People are not concerned about ease of payment, you know, Mr. Vice President. When you hear the cries of the people who have to get maintenance, you know what their cry is? Not when it's going to be, not how it's going to be paid, is when it's going to be paid. So it is not ease of payments that they are concerned about. Ease of payments is not going to bring any relief to anybody. It is enforcement of the orders that single mothers have every day. And when they can't enforce those payments by court orders, they can't get anything. And if you know the plight of those people who are on the ground and have orders for maintenance made in their favor, you know what they cry out for? They don't go to the court, they go to the police stations, and they will tell you the policeman don't want to serve the warrant. That's true. Right? They get frustrated by the idea that months and sometimes years will go by. And what you have, people who orders for maintenance have been made against. You have children suffering because parents cannot enforce those orders. And if you really want to bring relief to people, poor people in Trinidad and Tobago, because this bill, Mr. Vice President, have nothing to do with poor people, you know. It have nothing to do with bringing any relief to any poor people in this country under the guise of ease of payments. The relevant question that will be asked and will be answered here today is whose pocket is going to be filled when this piece of legislation is passed? And the answer to that question is very easily answered, Mr. Vice President. When you go down to the company's registry and you search who are the directors of the companies to be benefited from this piece of legislation, it's not the people who studying ease of payments. It's going back to the same saying, the 1%. That is what this legislation is about. That is exactly what this piece of legislation is about. It is about taking from poor people and giving to one fraction of people. That is what it is about. And you've heard Senator Chote mention about this practice direction that was signed off on the 18th of May, 2018. There's a history to this, you know. So let me bring to light what transpired with this, Mr. Vice President. The practice direction that was promulgated in some form or fashion on the 18th of May 2018 wasn't the first dose that we got of this, you know. The first dose we had of this was in March. In March of 2018, the judiciary went out and issued something, and that's the best way I can refer to it, because the judiciary has a way of issuing things these days that we have no description of it. In the Trinidad and Tobago Gazette, volume 57, Friday the 9th of March 2018, number 28, at page 249. That's when this started. Under the hand of the Honorable Chief Justice, 9th of March 2018, we had something called a practice guide. I have the CPR here. Under Part 4, you have some powers that are given to the Chief Justice to make something called a practice guide. But let me tell you what transpired. Because you know what I take great umbrage of, Mr. Vice President? If something has gone wrong, come to the Parliament, be upfront and straight with the people and say, we've come here to fix something that went wrong. We have no problem with that. We will help you. But don't come here under the guise that you come with this ease of payment. When truth and in fact is, you have an illegality taking place in this country by none other, Mr. Vice President, than the judiciary of Trinidad and Tobago. The judiciary of Trinidad and Tobago. So on the 9th of March, there was something called a practice guide, court pay system for the payment in and out of court of maintenance payments. Well, when you compare, and I'll come to the Audit and Exchequer Act and this act, and we'll do some comparison. When you compare the practice guide on the 9th of March and the practice direction on the 18th of May, all that happened here, Mr. Vice President, is that the judiciary went and put out something in the Gazette that had absolutely no authority or basis in law. It wasn't even properly drafted. Right? And when you compare the document in March with the document in May, on the face of it, you wonder how something like this could emanate from the judiciary of Trinidad and Tobago. How? This document purports to be the precursor to what we had in May. You know, Mr. Vice President, when the document that is signed under the hand of the Chief Justice was issued on the 9th of March 2018, talking about court pay and court orders and what has to be paid. You know, the public wasn't even told in March what the fees would be charged for the transactions that they are being told, right? I'm hearing over and over it was voluntary, but I'm coming to that. So this document, somebody informed the judiciary. I don't know who in the judiciary, I don't know who informed them. The judiciary doesn't tell us. So somebody informed them that what happened here wasn't right. So they come to correct it in May. No problem. In May of this year, the judiciary issues a practice direction. The authority for that is under the CPR, Part 4, telling us about court pay and a custodial account. So it says a custodial account means a bank account at a commercial bank opened in the name of the judiciary for the purpose of receiving and paying out maintenance funds in accordance with court orders, and for which financial reports would be provided to the court through the court's court pay system and bank reports. And then we come down under the subheading of transaction fee. When submitting a payment using the court pay system, the payer is charged a non-refundable transaction fee for each transaction submitted. So by this practice direction, the judiciary has the authority to charge people this non-refundable fee. Now, I've heard it by a number of persons say here today that it was voluntary. I heard the Attorney General in his contribution say, well, how it could be illegal? It's a court order. How it could be illegal? It's a court order. Well, Mr. Vice President, court orders are made every day. The fact that it's made by a court doesn't mean that it is automatically illegal and cannot be set aside. If it's illegal, it can be set aside by a higher court. It happens all the time. That's what judicial review proceedings are for. Magistrates make unlawful orders all the time, and they are set aside in judicial review proceedings. So the submission that because it's made by a court, somehow it can be illegal, it's absolutely without any legal authority or basis in law. Let me say that from the outset. But there's something shocking. Just like the Attorney General said, it was shocking about some of the things he read. There is something shocking about this practice direction. Let me tell you why. I don't know that the judiciary is a commercial enterprise. The judiciary is supposed to be a service provider. It provides a service. It dispenses justice to the people of this country, right? And I cannot fathom the idea that the judiciary will issue a document and say guidelines for the drafting of orders for maintenance when monies are to be paid into court. So the judiciary is telling judicial officers, high court judges and magistrates, Judges of the Supreme Court. The judiciary is telling them. Hear what the judiciary is telling them, Mr. Vice President. Where it is intended that maintenance payments are to be paid into court, and the judicial officer orders that the payments be made into court using court pay, the judicial officer should seek to ensure that the maintenance order provides clarity in that it clearly indicates how compliance can be achieved. So this practice direction is telling a judicial officer, a Supreme Court judge, and a magistrate how they must draft their orders. Hear what it says. To achieve this, guidance is given that it is best that these orders include, this is the Chief Justice, the Chief Justice is writing this and sending it out. The orders must include, in addition to the usual directions for maintenance. So the usual directions is what you have to pay, right? That's the usual thing. Here what you must include. A further direction that the said maintenance sums are to be paid by the payer into the court's custodial account. Into the court's custodial account. When this order is made, Mr. Vice President, not everybody here is a lawyer. When this order is made, this has the sanction of a court of competent jurisdiction. No, it doesn't become obligatory. It is mandatory. Because if you breach this order, you are subject to the sanction of the court. And the judiciary is using its power to issue a practice direction. Where it gets this power to impose this, I don't know. But the judiciary is using that power to direct its judicial officers that in court orders issued in maintenance matters, a further direction that the maintenance sums are to be paid by the payer into the court's custodial account. Where applicable, well, that is in relation to minors, let's leave that. 3, the amount that is to be received by the recipient. 4, the said sums are to be paid into the court by paying them into the court's custodial account using the court pay system and paid to the payee using the court paid system. This that is being promulgated here, that is being directed to judicial officers, is for judicial officers to sanction this system that has absolutely, as we speak here today, no authority in law to be charging recipients of the court this fee, you know.
Senator, almost all of the speakers that have gone before have spoken about that particular system, which is court pay in the courts. But each and every one of them have tied it to the bill that's before us, particularly Clause 15.1 in relation to the ability to make rules. What is happening with your particular presentation? It's starting to sound as a debate on something that has happened in the judiciary. So either you tie it particularly to the bill, understanding that this has been done before by other speakers, and just be careful, because I'm hearing you talk about the practice direction, and the Chief Justice has done this, and judicial officers have to approve this or approve that. But when you do that, you're actually talking about functions and things that have happened in the judiciary. And what we're dealing with here is a methodology and a system for payment that is being put forward by the bill that is before us. So tie it into the bill that's before us as you move forward.
I'm obliged, Mr. Vice President. I'm grateful. Sure.
Thank you, Honourable Senator, for giving me. May I just ask if you could elucidate a little bit further on what you consider the judiciary's illegality is specifically in law? I appreciate the general submission, but it'll be very helpful if I could understand specifically what the illegality is.
Sure, I'm obliged. Mr. Vice President, to come in line with the guidance that you've given, I too have a concern that Section 15 provides that the Rules Committee established under Section 77 of the Supreme Court of Judicature Act may make rules of court. And then it says, for providing for the payment of any convenience fee, transaction fee, or other fee in relation to payments into and out of custodial or custodial bank account for carrying into effect the provisions of this Act. That is Section 15. Mr. Vice President, for the benefit for the benefit of for the benefit of the Senate, the powers that are given pursuant to that particular provision under Section 15 to the Rules Committee are set out in the Supreme Court of Judicature Act at Chapter 401, Section 78. And if I can be allowed to just direct you, Mr. Vice President, to Section 78, it says, Section 78, the rules of court may be made under this Act for the following purposes: for regulating and prescribing the procedure, including the method of pleading and practice to be followed, and fees to be taken in the Court of Appeal and the High Court, respectively, in all causes and matters whatsoever in or with respect to which those courts respectfully have, for the time being, jurisdiction. So, the Rules Committee, which this piece of legislation that we are debating here today is incorporated in Section 15.1 as being, it is proposed that the Rules Committee is going to make some kind of rules to regulate what is going on here. The point I'm trying to make, Mr. Vice President, with respect to the legislation, is that if we are being asked or if we are being told that the Rules Committee is the proper authority to make rules, regulations, or guidelines in relation to the bill that we are passing and the procedure for this payment, what I'm trying to point out, Mr. Vice President, is that the government must tell us what is the position where there has been an absence of any rules, there has been an absence of any statutory underpinning for this process that has been engaging the entire country since March of this year. And it is like two examples of the cart being before the horse, because one would have thought the legislation, how I envisage this would be done, is that legislation would be passed. When the legislation is brought to the Parliament, we would be provided with the rules that would govern how the legislation is to be implemented. And we will have a true picture of legislation and the rollout of how that legislation is going to be rolled out and what the Rules Committee is considering. Because unlike the other pieces of legislation, Mr. Vice President, that we've passed with a proclamation clause and we've been told by the Attorney General on many occasions, we will get regulations as they come. This is dealing with public money. This is dealing with money that is being taken from citizens every single day. And I am astonished, to use the words of the Attorney General, and Attorney General, I will answer that question in a short while. I just want to make this point. I am astonished that the minister in the Ministry of Finance, in her contribution, revealed to the Parliament and to the people and to the public that there are courts in this country operating now that have cash that is categorized as public money that by law under the Exchequer and Audit Act must be in the consolidated fund, somehow in a commercial bank account. I mean,
So the bank's lending public money.
it is incomprehensible that that could be going on. Because once you have public money, for those who don't understand how this works, Mr. Vice President, that belongs in the consolidated fund. The Exchequer and Audit Act mandates how it must be treated. And if you want an example, I can explain to you how it works. When a bailiff goes out to do an execution and they come back with whatever they've taken, it must be accounted for in a receipt book. That must go in the court, and the bailiff can't take it and say, I'm going to put it in Scotia today, and I'm going to pull it out tomorrow, and I'll carry it in the court when I'm ready, or when the debtor comes, I'll go and write a check and give it to him. It doesn't work like that. There's no intermediary in this thing. These are public funds. So you can't take it up. So when you take that money, and perhaps somebody will answer the question this afternoon. When $1 million is taken from the magistrate court and put into First Citizens, or put into Scotia, or put into Republic, or put into Royal, when it comes out, who gets the interest on that?
Honourable Senator, thank you for giving me. I know your time is precious. The law was specifically amended, these sections in the Supreme Court of Judicature Act, to take care of the Curvic case. In fact, it was Anand Ram Logan who appeared in that case, where the Privy Council indicated that the Post Office was no longer the authorized entity because it could not provide the facility, which demanded interest. And the Privy Council caused the amendment to the legislation, which is to put in an interest-bearing account. So it is, number one, the Privy Council case, an amendment to the law which specifically happened after 2002, and that's the manner in which it is done in compliance with the law.
AG, with the greatest respect, I am very familiar with KERVIC. KERVIC was the reason why Section 24A and Section 24B was passed and put into in 2005. KERVIC was in 2003. What the Honourable Minister was talking about, this is dealing with money that is supposed to be put into the investment fund of the Supreme Court. This, that, like Senator Chote had indicated before, what the Honourable Minister was indicating was that you have funds in a magistrate court in some drawer, and you take it out and go and put it in a commercial bank account. This has nothing to do with KERVIC, nothing to do with 24A, nothing to do with 24B. KERVIC is when you take money and you pay it into the Supreme Court, and the Supreme Court was mandated to set up a fund because interest, people isn't to get interest. KERVIC is simply about the fact that when you put money into the court, they are entitled to interest on it. And it mandated the Supreme Court to set up a fund called the Supreme Court Investment Fund. And that has relevance to the legislation because one of the people who can sign on the judiciary's account is the investment manager of the investment fund.
So this is completely different.
Right? So I'm not talking about investment, Mr. Vice President. I'm very clear about what I'm talking about. I am talking about, like Senator Chote says, you're going to magistrate court, you're on bail, you beg, you have nobody to take your bail, you tell the magistrate, Your Worship, can I get cash bail? Worship say 10,000. You go and put that downstairs by the clerk of the peace. That's what we're talking about. You don't take that and invest it in the judiciary under Section 24A and B. And you cannot take that money and put it in a commercial bank account and then pull it back out when you're ready.
Increasing the liquidity of the bank.
No, I am always pleased by the fact, and I apologize, Attorney General, you were not here when I made this point. So I want to, on the statistics issue, the Attorney General has provided us with the fact that in the period 2016 to 2017, you had $119 million paid in maintenance. But you know what would have been interesting, Attorney General? What would have been a very interesting statistic would be how much maintenance has been ordered by the court to be paid, that the poor single mothers or single fathers or fathers and mothers have not been able to collect. Because you see this 119 million, they're dropping the bucket, you know. In our program on the afternoon at 6 p.m., Mr. Vice President, I'm sure you're familiar with, you know what they call it? Deadbeat dads. You know what that is about? It's about this. About men who are not obeying the court orders that are made in their favor. And the point I'm making again in the presence of the Attorney General now is this. This is not going to help them. And they are the people that need our help. So if you really want to help people and you really want to bring relief to the system, let's get some legislation to enforce the court orders when maintenance payments are made. That's what we need. We don't need this. This is not going to help them. So this 119 million, it doesn't make any sense parading that around. Now, the Attorney General made a point that I consider it my duty to correct or to put right, or to attempt to put right. The Law Association did a response to the Attorney General after this matter was adjourned on the first occasion. Right, I have it here. And the Attorney General tried, in his piloting of the bill, said that he couldn't understand that courts all the time collect fines. And what is the big issue about this separation of powers argument? It just doesn't make any sense. Well, Mr. Vice President, let me humbly try to explain what the Law Association was trying to explain in their letter. The Law Association wasn't making the point that courts all the time collect fines. We all know that. It would be fundamentally flawed to even suggest that there is something. We know what the point the Law Association was making is to be found in their response at paragraph 8, where their issue was not the collection of the fine. This was the one that was sent out yesterday. 20th of August. Right. Sorry, Mr. Vice President. Thanks. At paragraph 8, the issue of the separation of powers was dealt with by the Law Association. And if I can try to just explain what the Law Association was saying, Mr. Vice President. They were not concerned about the fact that courts all over the country collect fines. That's the only place you could pay it. Their point was that when you open an account in the name of the judiciary, that is the issue that they had. It gives the perception, and that, let me just read into the record what they said. We perceive that a law which provides for the payment of fines imposed by the judiciary at the end of a criminal trial into an account in the name of the judiciary blurs these strict lines of separation and may give the appearance that the judiciary is a beneficiary of and therefore has a pecuniary interest in the outcome of a criminal trial. It had nothing to do with collection, Mr. Vice President. It simply had to do with the fact that the money that is going, that this money is perceived to be, that is proposed, to be put into, is going to be in the name of the judiciary. Part of that, I think the Attorney General has now suggested that the name, there's going to be a name change in terms of the accounts, and it will be known as a custodial revenue bank account. I don't know how much of that is going to take away the concern of the Law Association. Now, Mr. Vice President, let me latch on to a point that deals with this Section 4A, which is a new section that was handed to us this morning, about this conflict between the Exchequer and Audit Act and the act that we have before us. Mr. Vice President, the Minister in the Ministry of Finance, in her contribution, seemed to have proposed what we as lawyers understand to be the concept of implied repeal. And I'm trying to understand how it will apply in this case, but needless to say, we should not be presented, Mr. Vice President, with legislation that says if there is a conflict, this act goes over that act. The whole purpose of the legislative process is to ensure that there is no conflict. And therefore, if you want to present legislation, and this is not a criticism of the Attorney General at all, the Attorney General, as I have always said, and I will say it again, there's a legislative drafting department in the Attorney General's office that there is a lot to be desired of. And I say that openly without apology. But you cannot bring a piece of legislation to the Parliament and tell the Parliament, well, if there's a conflict, the Honourable Minister in the Ministry of Finance said, well, we should identify the conflict. That's not our job. The job of the legislative drafter is to ensure that there is no conflict, present a piece of legislation and say this is a piece of legislation that abides both by the Exchequer and Audit Act, or if we want to do something differently, this is how we're going to do it. There should be no opportunity for there to be a conflict. And therefore, that section, I join my colleagues who have criticized that particular section. Now, Mr. Vice President, I want to say, and I want to put on the Hansard, that I would like the Attorney General to tell us and tell the country between March 9th of this year, 2018, the Attorney General is the only person I know who has the authority to ask and may have custody and possession and control of that information. As a senator being asked to pass this piece of legislation, how much money has the judiciary collected between the 9th of March and as we speak here today in relation to the implementation of this process that has been put forward to us? I want to know that. I want to know what steps, because this legislation is not retroactive. So I want to know what steps are going to be proposed by the government to provide some kind of, and that is why I'm saying we're not criticizing, but to provide some kind of legal justification for what has been done. And let me answer the Attorney General frontally. The Attorney General asked me to explain how it is that this thing has been done illegally. Attorney General, the Supreme Court Adjudicature Act provides by Section 78 the manner in which the Rules Committee can impose fines, charges for the conduct of litigation. The CPR, as you very well know, is subject to the negative resolution of Parliament. So that is why we have parliamentary scrutiny to do that. how the judiciary could open an account in the name of the judiciary and have money going into that account by virtue of a practice direction without engaging us in the process that we are engaging here today. Because if this bill is passed, henceforth, what would be done would have the authority of the Parliament. That is why you've brought the bill, in order to allow the judiciary to open a custodial bank account, and you have said that the Exchequer and Audit Act provides for that. Section 112 of the Constitution provides for that. And what you've done here today is to come and do what the law requires you to do. But how could it be lawful, if you are right, for us to pass this legislation and say this is being done properly as we speak because you've done the right thing, but the judiciary has been doing exactly what you are saying we are proposing to do since the 9th of March? Because they have already opened a custodial bank account. They have already put money into there. But they have not asked for your authority to do that. They have not asked for the authority of the Parliament to do that. And my simple argument is, if they have done what you are expecting judiciary to do by virtue of this piece of legislation, it can't be that it was right then. It was right then and it's right now. Then that would mean what we're doing here is all superfluous. And it's a simple thing. I said, Mr. Vice President, if the judiciary got it wrong, then come and tell us they got it wrong. Let us fix it. It's not the first time it's going to happen. But we need to be told, and we cannot be engaged in this process without having all the cards face up. If the judiciary did it wrong, I don't see the Attorney General name or any advice. Senator Mark asked if any advice was, I don't see anything like that. If they did it wrong, they did it wrong. But the point about it is, you would have the consequence of it, Attorney General, is this. If I am right, people would have been charged a fee by virtue of this document since March of this year and continuing, that they have no lawful justification for imposing.
Thank you so much for addressing the point. Could you please disaggregate that argument against the very fee that is applied when you do a standing order fee under the umbrella of a court order? Because I did say that the judiciary's argument to me, which I have volunteered to the Senate,
Sure.
is this is subject to voluntary participation in a court order process only in the High Court, not in the magistracy, and that specifically the fee charge is accepted by the parties in the court order, and it's akin to, as the judiciary puts it, when you pay the transfer fee on a standing order arrangement, which has been, as you know, the standing practice for umpteen years.
Attorney General, there's a very simple answer that I'm sure you will understand what I'm saying. The court has a duty to adjudicate upon an issue between the parties. Mr. Vice President, how much time do I have? Until 3:40. 8 minutes, okay. The answer to that is very simple, Attorney General, is this. The judiciary cannot use the mechanism of a court order to impose a charge. That is the problem. That is the simple problem. Who has told the parties? You said they have told you, and I want to be very clear, they have told you that is a voluntary thing, and therefore is legal because the court is imposing it. No problem. The court can make whatever decision it has in terms of the dispute and come to a conclusion and make an order that $3,000 has to be paid per week for each child or whatever. No problem at all. Nobody can question that. The only person that can question that is a higher court. But you cannot use the mechanism of the court order. You were not here when I made the point about it. What this practice direction does is to tell a judicial officer, this is how you must exercise your power. It is the first time I've ever seen that. And part of that order is to impose the fee. So the court order is being used as the mechanism by which the judiciary is, I want to put in inverted commas, forcing the parties to accept this mechanism. And that is the difficulty that I have. So I want to say I don't accept for a minute that the court has the power to do that. Mr. Vice President, I have a letter in my possession dated the 29th of June 2018 under the heading of the Law Association that is written to Her Excellency the President, the President of the Republic of Trinidad and Tobago, Office of the President, Circular Road, St. Anne's, Port of Spain, signed by the President of the Law Association, Mr. Douglas Mendes, Senior Counsel, in relation to advising Her Excellency about not proclaiming two pieces of legislation that have been passed. I'm very disappointed that the Law Association has to go to that extent to try and correct what they conceive to be failings in legislation that has been passed through the Parliament. And it's a very, very serious thing, Mr. Vice President, because the powers of Her Excellency are very limited in what she can and cannot do in terms of the assent to legislation. And it ought not to be that we have concerns. If we have concerns, let our concerns be vented here. Let us be given the opportunity to correct the legislation and do it right. I have indicated to the Attorney General why I consider it to be wrong. There's no reason why we can't put ourselves collectively together and get it right. If something has been done wrong, the Attorney General can take advice and find out if that is so or not. This is not about who wins and who loses, because if legislation is passed that does not accord with the rights of the citizens, it does not accord with the Constitution, and it does not accord with existing law, then we would be doing a disservice to the people of Trinidad and Tobago. And that is not right. And therefore, I don't see anything wrong in us taking the time. There's no rush. The law term is opening next week. I don't know what we are going to hear on when the law term opens. I don't want to hear about this and about court pay and all of that. Nobody holds a brief here for anybody, Mr. Vice President. We hold a brief for the people of Trinidad and Tobago. And that is what we must understand is our duty. We have a duty here. The Attorney General, in passing, in crosstalk, said, well, he doesn't expect that we would support the legislation. If I was not prepared to share my view as to why it is wrong and how we can fix it, then I'm wasting my time. And I'm wasting the time of everybody here. I've told the Attorney General. The Attorney General has taken on board the comments of the Law Association. We need to get it right. It cannot be right, Mr. Vice President. It cannot be right, and again I say, I lay no blame at the feet of anybody, but it cannot be right for you to bring legislation to the Parliament, Section 9A of the Act that is presented to us this morning as an amendment, because the Law Association says there are a number of pieces of legislation that this thing affects. Because under the Petty Civil Court Act, you have Petty Civil Court rules that require payment into court. Under the Summary Courts Act, you have payments that are required into court. Under the Parent and Guardianship, you have things that are required into court. Section 24A and 24B of the Supreme Court Adjudicature Act is affected by this. It cannot be right when we point out these things for the drafters to simply come and say a requirement under any written law for monies to be paid into a court, judiciary, magistrate, registrar, court executive administrator, marshal, deputy marshal, second deputy marshal, a deputy assistant, a bailiff, a magistrate registrar, and you just one umbrella, right, and say you could do that by putting it in a custodial bank account. That is not the way it is supposed to be done. The reason why the Law Association put in its letter simply said, let us look at the pieces of legislation. What is wrong in looking at the pieces of legislation and getting it right? Section 24A and 24B of the Supreme Court Adjudicature Act says where you have to make an investment into the Supreme Court, you put it into that fund, right? So, as a lawyer, a client comes and you have money that has to be invested by a payment into court. Are you going to put it in the investment fund of the Supreme Court, which might invest it in the unit trust? Are you going to put it in the custodial bank account that will invest it in Republic Bank? Are you going to put it in another account that you might have in FCB? Where? How? How is it going to work? Where you have different institutions that are managing different funds that are put there for different purposes in the court. What we are required to do is to look at the different pieces of legislation and say, listen, we all want to get everything under one umbrella. This is what we want to do. This is how we should do it. So let us sit with the different pieces of legislation and get it right. What should have been done is we would have had a schedule or another section to this piece of law that tells us this is amended, this is repealed, this is amended, That is what we're supposed to, that is not our job. That is the job of the drafting section of the Attorney General's office. And let us get it right. We cannot continue to come here over and over just because certain concerns are raised. Wash job, you just do it and that's the end of it. You don't do it like that. So, Mr. Vice President, the concerns that we have expressed to the government, to the Attorney General, are concerns that are genuine and based upon a serious concern that we want to get it right. There are no provisions, following on from what Senator Chote said, there are no provisions in this law that deals with any offenses for the disclosure of confidential information of people who will be using the system when that information comes into their possession. There's no offense. So anybody could take anybody's bank account with whatever information that they have. Don't you think that we should be providing some kind of offense for people who misuse that, who have possession of that information and misuse that information? It is almost in every other piece of legislation where you have persons carrying out a public function in the public service that deal with confidential information. We had it in the SSA amendments. The Attorney General is familiar. It's in the Financial Institutions Act. Let us get it right. Let us provide for some offense that will be a deterrent to people who have the opportunity to misuse people's private information. And therefore, I can't understand how we could be asked to pass a piece of legislation that doesn't give the users of the system. It's not good enough to put it, it's not good enough to put it on our website. Let us put it in the law and give the people the confidence to use the system that you want them to use. So with those words, Mr. Vice President, I hope that we have been able to express to the government and the Attorney General our concerns and they will be taken on board. I thank you.
Senator Roach.
Thank you, Mr. Vice President. Mr. Vice President, just taking off from where Senator Ramdeen left off, my immediate concern with this bill, which appears, from my reading and from all intents and purposes, to be a very short bill, a bill of some 15 clauses, right, that is brought before us to deal specifically with, as it says, an act to make provisions for payment into court, into and out of court, to be made electronically, and into and out of a custodial bank account in the name of the Judiciary of Trinidad and Tobago, and for related matters. I have heard a number of concerns raised by senators this morning, and some of which, to me, pertains to the a more wider scope of addressing the concerns in perfecting or improving our legal system. Some of the concerns raised, I can see legitimate concerns, the bill at hand, and there are others that are much broader than what is before us. So I am not going to venture, I'm going to try to be disciplined and not venture into those other concerns raised. I'm also like to say up front that I've approached this discussion, as I approach most of the debates here, with a very open mind. Not yet willing to make a conclusion until I have had the benefit of hearing addressed by the Honorable Attorney General some of the issues that I consider to be pertinent to this debate. But immediately, what I can say, Clause 4A, which states in the amendment, which is now introduced us this morning, Clause 4A would provide for the Exchequer and Audit Act, Chapter 6901, to apply to this Act, and for this Act to prevail where there is an inconsistency with the Exchequer and Audit Act, Chapter 6901. My only concern, and I will certainly hope in the Attorney General in his winding up, he doesn't need to interrupt me at this point in time, but certainly in his winding up, that he will probably give some sort of a reason why he will want to exempt you will want to give preference to this act as opposed to the Audit Act, which is much more comprehensive and is certainly a very robust and significant act in the affairs, the financial affairs of the Republic of Trinidad and Tobago, giving the Auditor General a certain significant oversight over the expenditure and collection and so forth, revenue. So I await his response in this. And what is one of my colleagues, I think my colleague Dr. Mahabi was saying, he has never seen such a clause. It is since in his existence in the Senate. So I told him the only other place for sure. It appears from time to time in different acts, but certainly in the Constitution, you will put in something where any other law is inconsistent with the Constitution prevails as the supreme law, right? And as Senator Ramdeen was saying, we are here to present good law. And, you know, why should such a clause be imposed here? It's only like you bring in upfront flawed law. But one can never be comprehensively and perfect in what you do. And sometimes as lawyers, you know, you always have what you call a sweep-up clause, or you present clauses that will help prevent in anticipating that things may be interpreted differently. We have a number of lawyers in this Senate, and we can look at whatever piece of legislation can be, and we have maybe 15 of us, and we have 15 different interpretations of it. My concern and my immediate concern has always been when we are in debating law that we are as legislators about to pass, is that laws are not being made ad hominem. As much as the law association, of which I'm a member of, has a pertinent role in the administration of justice. And so the law association in itself does not have a monopoly over what should or should not go in to legislation. I think the wider public, as much as your contributions are welcome, I think the wider public should be encouraged more often than not to participate in it. But certainly, the language of what we use in formulating laws should be so simplistic that the ordinary person can pick up and be able to follow immediately in this act or any other act that is coming before us. What exactly is the law seeking to achieve? What is their responsibilities? And what are the consequences should they fail to follow whatever is being imposed upon them, reasonably and justly so. And, you know, my mind went back to St. Thomas of Aquinas in his treatise on the law. And he said the essence of law is an ordinance of reason for the common good made by one who has care for the community and is promulgated, right? An ordinance of reason, meaning it has to be reasonable. It's based on reason, right? And it's for the common good, not for an individual person, but for the common good of the community. And this bill, what it seems to suggest to me, is seeking to improve our legal system. Is one aspect of the number of ills that we have pointed out over the time I have been here about in trying to perfect, correct, or advance our legal system to be more efficient, more user-friendly, and gain people, the ordinary persons, the ordinary citizens, confident in our rule of law. And this bill just, to me, seeks to provide for the payment of maintenance into a more efficient and modernized way of collecting and dispensing with monies received for a specific purpose. And to me, if I'm a member of the public listening to the debate that is going on, I mean, I think it's quite easy for one to be a bit confused exactly what it is this bill is really seeking to do, right? Early on, there was concerns about who should have the signature, whether the signatories on this should be this person or that person, and a number of other issues. But to me, one of the fundamental things is that what it is seeking to do is to set up an account that you can more efficiently collect and disperse with maintenance ordered by the courts. And whether or not what is being provided here has the checks and balances to make it transparent and to make it as reliable and safe as possible in dealing with these transactions. No transaction electronically or otherwise is foolproof. That is why when you use your credit card and it is skimmed or whatever it is, that sometimes the bank has a responsibility to reimburse you, whether or not, once you can prove that you have not dealt with it, you haven't given permission if it has been fraudulently interfered with. So using debit cards or whatever cards to top up to pay these things, I mean, yes, I mean, there may be flaws, there may be opportunities for instance of misuse and abuse of the system. But I think within the electronic world that we are moving in right now, there are a number of things that are being always perfected to cater as the faults present themselves. And I do not see any significant objections. Bearing in mind, as I said, one of the concerns I have, my main concern is with the exemption of the audit, the exchequer not being able to have precedence over this piece of legislation. But I think it's a legislation that is necessary, is required, and that there is ample provisions referenced by the various acts once they are they reflect accurately what the Attorney General was saying that they cater for to offer the protection that is being sought and being questioned. And I am willing to support this initiative once I am satisfied at the end of the Attorney General's explanation why he will not, hoping that he may see, I don't know what he has to say, but whether or not he will maintain the position as it is in Section 4A, or he will revisit it and delete the fact that the Act is not to have precedence where there is inconsistency with the Exchequer Act. The only other comment I would like to make on this bill is that Senator Ramdeen had made a comment about the earlier on. He said something about the court executive. I think people were making a lot about the court executive and being who's accountable, whether the deputy court executive. And from my knowledge, I know that in all ministries, the permanent secretary, like the account executive here, will be the accounting officer of the office of the ministry, and therefore is personally liable on the public service regulations for anything that goes wrong, that metaphysics has gone wrong. And in this instance, I see the similar thing applies here, and therefore, I mean, those concerns are not that of such a nature that cannot be explained with empirical evidence that has gone before, which is the norm in public service accounting. You know, Senator Crease, the former PS, I sure could attest that if he's speaking on this bill, that the accounting officer plays a significant role and is not a law unto herself or himself, as the case may be. So, you know, so Mr. Vice President, I am heartened by the efforts being made here. I am open-minded at the end of the day for the Attorney General to address the main issue that I have raised with that. And other than that, I am willing to support this bill, provided that I can be satisfied at the end of what he has to say pertaining to Section 4A. Thank you very much.
Senator Hosein.
Thank you very much, Mr. Vice President, for allowing me to contribute to this bill before this Honorable Senate. And I would also like to welcome back all my colleagues after the vacation period. And if you would also permit me, Mr. Vice President, today is a very significant and memorable day. As we know, in 2001, 14 Trinidadians had lost their lives in the 9/11 attack. And I would just like to express my condolences to all of those families after all of these years have passed also. And Mr. Vice President, this bill before us is one that it's a revolutionary bill in terms of trying to get the judiciary in terms of with technology. While I personally support the concept of convenience in terms of making access to justice, one, through e-filing, which is also part of the bill, and also convenience at the end of a court matter in terms of the payments of fines and maintenance. What we must not allow ourselves to do is that support the concept, but also support an illegality. Now, much has been said about the illegality of the payments that has gone before by my colleagues on this side of the House. And Mr. Vice President, as I said earlier on, the bill has two aspects. One, dealing with the e-filing of court documents, and the other dealing with online electronic payments. And I will try to elaborate on both aspects. So I will first start off on the one which deals with the online payment, which the majority of the bill seeks to address. And Mr. Vice President, one of the concerns I have with regards to the bill are the signatories of the account. Now, under Section 6, Clause 6 of the bill, the account requires 2 or more signatories to each custodial bank account. And this only deals with the custodial bank account. It doesn't deal with the custodial trust bank accounts. And those persons are the court executive administrator, the deputy court executive administrator, authorized by the court executive administrator, and was recently added the registrar or the chief magistrate. Now, Mr. Vice President, the position of the deputy court executive administrator, as the Attorney General mentioned, is a contract position, as opposed to an appointment by the Judicial and Legal Service Commission. Now, the court executive administrator is appointed through this independent service commission. So, the problem I'm having with this deputy being a signatory on the account is that the Law Association also mentioned it in their submissions, is that this person can in fact be influenced through pressure in terms of the person who appointed them to the position. Whereas if you are appointed by an independent service commission, you have that security of tenure and that freedom of political pressure or any other influence that may be exercised upon this person. So it is my recommendation is that this deals with monies, and if there's any allegations of wrongdoing with respect to monies collected by the judiciary, it can in fact bring the judiciary into disrepute. Now, the judiciary should be one of the 3 institutions of the state that should stand without reproach. It should be that citizens feel confident in the court systems in order to protect their rights, their freedoms, and their privileges. Now, if there are allegations of a court being engaged in financial wrongdoings, then it erodes the confidence in which any democratic population will have in that judicial institution. So, Mr. Vice President, I would humbly suggest to the Attorney General and the government is that the signatories on these accounts should be persons who are appointed by an independent service commission, that being the Judicial and Legal Service Commission, rather than someone who is being appointed to a contract position. Now, the second point I would like to make, and it was also raised by the Law Association, is with respect to the custodial bank account. The issues are raised with regards to lack of rules, regulations, guidelines. And normally, the Audit and Exchequer Act would be that central piece of legislation that will govern the way in which a public account is regulated by the accounting officer. Now, if Section 4A of this bill now exempts the Exchequer and Audit Act, then where are the rules, where are the guidelines, and where are the checks and the balances that are going to take place with respect to one person inspecting these accounts and ensuring that they are regulated in accordance with the law of the land? And Mr. Vice President, this custodial account will hold money such as fines. The Attorney General explained it will hold revenue of the judiciary, which are marshal fees, which are filing fees, and which are fines. And these fees, Mr. Vice President, figures were presented to us. They came up to marshal fees for the period 2016-2017, came up to $24,300. Fees of the Supreme Court, $2.3 million. Fines, $29.3 million. So these accounts hold significant amounts of public monies. And if there is no oversight on these accounts, then, Mr. Vice President, again, the point I made earlier on, it will erode the public confidence with respect to the independent judiciary of this country. And the judiciary should not be dragged into any mess with regards to financial wrongdoing, Mr. Vice President. Because it is not a parlor you're running. This is a judicial institution. This is the institution that protects every citizen of this country. And we must pass laws in this country, not sanctioning an illegal act that has already taken place. Well, if you may, Mr. Vice President, without breaching standing orders, all my colleagues has already dealt with it. If there is no legal basis in which fines, fees should be charged by the judiciary, then how it is a practice direction dated, I believe it's the 18th of May, allowing the judiciary to collect monies, holding it in an account, and also collecting these fees for these transactions, Mr. Attorney General. And the other point is that you also asked Senator Ramdeen with regards to those payments and standing orders in terms of orders that the court will make with respect to standing orders. Now, the Attachment of Earnings Act, the Attachment of Earnings Maintenance Act, that actually empowers the court to make those types of orders in terms of also covering fees and the maintenance. In this case, there is no legal basis in which a court can make this order. So, Mr. Vice President, as a responsible senator and a member of the opposition, we will not support such an act. With respect to the other issue with regards to the technology that will be employed in this bill, in order for the operationalization of this bill, we must also look at the security framework of electronic payments. And since we live in such a technologically developed society, and we have seen over and over where persons who do online transactions, they face exposure to data theft, stealing, fraud. And Mr. Vice President, Trinidad and Tobago also suffers those issues because daily there are credit card frauds. When the FIU filed a report, they would have indicated how many of these suspicious transactions take place on a daily basis. So, Mr. Vice President, we have had no assurance with regards to these payments being properly encrypted, which provides confidentiality, authentication, and integrity. With respect to digital signatures, with respect to authentication, Mr. Vice President, integrity protection, and non-repudiation. All of these are issues with regards to security of data. Now, there's also the issues of fraud risk. There's also the issues of privacy and anonymity, because there's in Trinidad and Tobago, there currently stands the Electronic Transaction Act. And this act covers all electronic digital payments. And Part 8 of the act, which is yet to be proclaimed, deals with consumer protection. And consumer protection, if you may allow me to quote from the act, Mr. Vice President. Yes.
Not with payments of this type. You're aware of that, right?
Mr. Vice President, the Electronic Transaction Act deals with both goods and services.
Yeah, but not of this type. Proceed.
Because if the judiciary is providing a service, then it must also be covered. Because you would agree with me that the court pay is a service being offered by the judiciary.
Someone else.
So a person using electronic means to sell goods or services to a consumer shall, before the conclusion of the electronic contract, based on such transaction,
You mean
provide the following information to consumers in respect of the terms, conditions, and methods of payment, in terms of the details of and conditions and policies related to privacy, withdrawal, termination, return, exchange, cancellation, refunds, the arrangements for delivery or performance, Mr. Vice President. Now, where is the consumer protection with regards to these online payments? There is none, Mr. Vice President. I humbly say so. So this, and even in the FAQs that Senator Chote would have read out, there is no guarantee that your information will be protected. They gave some acronyms that nobody really understands how your data will be protected. They also told you that you're exposed to credit card skimming, I believe, in terms of these transactions, Mr. Vice President. So then, what guarantee is the government, the Attorney General, and the judiciary giving the consumers of this service any assurance that their data, their monies, their transactions will be properly protected when they use this court-based system, Mr. Vice President? The other point I would like to make, and it will touch and concern the custodial trust account, which is the investment account of judiciary. The Attorney General would have mentioned the case of Kervek, and that was a case in 2002 decided by the Privy Council. In 1998, a court order was made where Kervek had to pay security of cost of the sum of $250,000. The assistant registrar then placed the money into the Treasury, whereas, so there was a claim being brought against the Attorney General for the actions of the assistant registrar. The Privy Council subsequently found that the assistant registrar acted wrongly and that money should have been placed in an interest-bearing account, which would have led to the amendment of the Supreme Court of Judicature Act at Section 24A, 24B, 24. It's 24A, Attorney General. And Mr. Vice, 24A. And Mr. Vice President, with regards to this now, there's a seemingly inherent conflict. And I say so because certain monies are being ordered to be placed into the custodial trust account. And those monies deal with maintenance payments and any other payment made pursuant to an order of court, rules of court, or any other law which is not by its nature revenue. 24A of the Supreme Court of Judicature Act states that notwithstanding any written law to the contrary, all monies paid into the High Court in any cause or matter, and all monies paid under the control of or subject to the order of a court or a judge or master of the court may be invested by depositing such monies in an interest-bearing account in a financial institution. Now, Mr. Vice President, in this case, if a court makes an order for example, security of cost or payments into court, then, Mr. Vice President, there's a conflict into which account the money should go, whether it should go into the investment account that is already established, or whether or not that money should be deposited under the custodial trust bank account. And when you read 24A, it starts off by saying, notwithstanding any written law to the contrary. Well, Section 5, subsection 2 is a written law to the contrary. So does it mean that any orders made with respect to non-revenue monies go to the investment account? And that is a point that I would like the Attorney General, I will seek some clarification from the Attorney General on, because I'm still trying to grapple with whether or not money is being paid into the account, which account it will actually be deposited into, Mr. Vice President. And Mr. Vice President, these are some very short concerns that I wish to raise with regards to this limb of the bill in terms of the electronic transaction payments. Now, there's the other limb of the bill that deals with the e-filing. And I think that it is time that Trinidad and Tobago move towards, or go towards that direction in terms of e-filing. And right here in Trinidad and Tobago sits the Caribbean Court of Justice. And in the Caribbean Court of Justice currently, there is a system or a platform for e-filing. In the Eastern Caribbean jurisdictions such as St. Lucia, they also have the same method of e-filing. And Mr. Vice President, you will, the Attorney General could also attest to this as a practicing attorney. You have to run down to the High Court in the Hall of Justice. You have to go down to San Fernando High Court in order to file certain documents. Whereas when you can draft a document in the convenience of your office, upload it to some website that the judiciary manages, and automatically your case is filed. So you can actually alleviate some of the traffic. You can alleviate some of the workload of the judiciary because it's overworked, Mr. Vice President. So, and I understand it's e-payment, Mr. Attorney General. I am not against, I don't know if I'm making myself clear, because I am not against the electronic payments. I did say in the beginning of my contribution that I did accept the concept, but what we don't accept is what the bill is trying to sanction, an illegality that took place already, Mr. Vice President. And that is the point that I made earlier on at the beginning of my contribution. So if I may continue, is that with the e-filing system, we would now see that new rules would be drafted in terms of how documents are filed, how documents are served, and how do we authenticate these documents. When I looked at the Caribbean Court of Justice website, I saw a practice direction outlining all of these details in terms of how documents are filed and authenticated through the court system. And Mr. Vice President, it shows how easy cases can move forward now, because when you go to court, there are several bundles of documents you have. Now, all of that could be condensed into the convenience of a tablet or a laptop or a computer. And it is really about time that we move our court and judicial system to that level, Mr. Vice President. But when you see the reality of Trinidad and Tobago in terms of the condition of our judiciary, where we have a shift system in San Fernando, where the Princestown Magistrate is closed for a couple days, that maintenance payments are being made out of, I believe, a truck, Mr. Vice President, then do we really have hope that this will come anytime soon? Or is it that we are just going to pass this bill, it's going to be proclaimed and assented to, and then it's left there, Mr. Vice President? Is it that the government is really concerned about moving the judiciary forward? Or is it that they're using this bill for increased revenues, Mr. Vice President? Because it seems that all this government does is try in any way to get additional revenue in order to spend on all these vanity projects, Mr. Vice President. So the point here is that the bill currently in its current form lacks accountability, and it lacks transparency in terms of the way in which these public accounts are going to be dealt with. There's conflicts with other laws, Mr. Vice President. It is very concerning that they would want to accept the Exchequer and Audit Act. I hope that the Attorney General can give some sort of clarification with regards to that issue. Also with regards to a commitment in terms of when the e-filing will come on board. I will be happy to see that, or give the country some sort of hope that this will come sometime soon, Mr. Vice President. And with these few words, I would like to end my contribution. Thank you.
Scott?
Thank you very much, Mr. Vice President, for this opportunity to contribute to the debate on the Payments into and Out of Court Bill 2018. There was a time when I was in this Senate that there were so few lawyers that I could be sure I would say something and no refutation would come for a few days. But littered is the word that comes to my mind, although I'm sure attorneys won't be happy with it, but we seem to be littered with attorneys here. So that I will approach with caution what I want to say. A prior speaker in this House lamented that there appeared to be no enthusiasm or no enthusiastic embrace of the bill. And I thought I could offer some solace if I say that I am quite enthusiastic about the concept of easy payments being made, in particular in the situation that have been described by the member piloting the bill of people who have to receive maintenance money having to line up or to travel from Roxborough to Point Fortin. But like those who preceded me, I am fearful that we seem to have rushed to produce this piece of legislation, both incarnations, and it required a little more care, caution, and research so that we could be assured that we have a bill that is close to being perfect. This rendition of the bill doesn't satisfy me that it has had the benefit of that kind of caution. But because the Attorney General is known for his very wide research and his diligence in dealing with these matters, I'm going to frame my contribution in the context of things that he could look at and clarify for us in the reply. That is probably the best way I could do this. May I just make clear that I am a member of the executive of the Law Association of Trinidad and Tobago, the council, pardon me, and therefore the things that have been said by and on behalf of the Law Association here are concerns which I support. Until today, I had not known that there had been a response to the letter from the Attorney General, the Honorable Attorney General, in July, I think he said it was, 2 July. But even so, having heard snippets of it, I am still of the view that the Law Association was right to recommend caution to the Honorable Attorney General and to suggest that he delay a bit longer so that all voices could be heard in this matter. And it could only enhance the quality of the bill if he were to do that. It is clear that the bill does not set out to deal with retroactivity, so that what is already ongoing may well continue for all we know, and if it is not lawful, I'm sure that will be straightened out, but what I'm addressing is the fact that there is no need for urgency now, because there's already a way of collecting payments and paying out maintenance monies, and until such time as the judiciary has been proven to be wrong, those who are benefiting from it should continue to do so. I'm sure we can correct it if it turns out that it is wrong. So here are the observations that I wish to make so that I can have the benefit of the Attorney General's intervention later in the reply. And they are primarily based on the way the Exchequer and Audit Act is framed and what this bill sets out to do in relation to it. The first thing I want to bring to the attention of the Attorney General in seeking his later guidance is that the Exchequer Act defines public monies in this way. It says in Section 2, public monies include any, and I'm preceding, any monies held, whether temporarily or otherwise, by an officer in his official capacity. Officer means any person in the employment of the state. So that on first blush, it would appear that such monies as are being contemplated by the bill before us will be regarded as public monies. Now, public monies is distinguished from revenue, and I'm making that distinction now because of something I referred to later. And it says revenue means all, and once again I'm preceding, fees, licenses, taxes, etc. The distinction, therefore, is clear, but it also goes on to say such that are within the power of the Parliament, over which the Parliament has power of appropriation, so that revenues are clearly distinguishable from public monies. Fees, duties, over which the Parliament has power of appropriation are what are regarded as revenues. The bill deals with both public monies and revenues and distinguishes them, as I will point out in a moment. If you look at clause 5, I'm reading from the amended bill. Clause 5 says, there shall, 5.1, there shall be established and maintained accounts to be known as custodial revenue bank accounts, which shall be held under the name of the Judiciary of Trinidad and Tobago at a financial intermediary in Trinidad and Tobago to facilitate the payment into and out of court of fees, fines, and any other payment made pursuant to an order of court, rules of court, or any other law which by its nature is revenue. So it no doubt has been crafted with an eye on the Exchequer and Audit Act, and it distinguishes revenue from this other kind. 5.2, there shall be established and maintained accounts to be known as custodial trust bank accounts, which shall be held under the name of the Judiciary of Trinidad and Tobago or a financial intermediary in Trinidad and Tobago to facilitate the payment into and out of court of maintenance payments and any other payment made pursuant to an order of court, rules of court, or any other law which is not by its nature revenue. So I am assuming, and until I hear a correction, that the custodial trust bank account is where you put public monies being money received from anyone by an officer, a person in the employment of the state. Those monies, my reading suggests, come squarely and are intended to be squarely under the control of the Exchequer, as the Exchequer and Audit Act says, and therefore under the control of the Auditor General, and no one else. So that even though it is intended by this bill to create or to empower another officer of the state to collect money, that money comes under the control of the Auditor General. And it is not so, it is imprudent to suggest that, well, we will give preeminence to this act if it should become an act, if it should be passed, over the Exchequer and Audit Act. My suspicion is that the Exchequer and Audit Act was meant to control how we treat with public funds and to focus the control and management of those monies in one superior body, the Auditor General. But somebody will point out that I am in error. There really is a minister contended for in this bill. The Treasury, as defined by this act, means the minister. And so we know immediately that although the bill before us makes no mention of a minister, that the Minister of Finance really will have direct access to these monies and may determine where they go and how they are treated. Under the Exchequer and Audit Act, the minister, well, let me put it differently. The Act creates the Act refers to the Consolidated Fund. And it says of the Consolidated Fund that that is the place where money shall be placed and shall be treated with in a certain way. So that it is not a matter of you establish the court pay system or the power, what do you call it, power pay, some other system for paying monies. And when those monies go in there, no one else can determine how it is to be treated with, except the officer who is now the signatory to the account. It seems to me that there's another hand at play, and we do not remove the power of the minister or the Treasury over these monies by this sleight of hand. I trust that sleight of hand is not going to offend the Attorney General. I'm really referring to the swiftness with which the rapidity, I think was a word I heard earlier today, the rapidity with which this was created, and may well not have had the benefit of further thought as to what shall become of these funds when they arrive in the custodial trust bank account or the custodial revenue bank account. So through you, Honorable Attorney General, I would want to hear later on in the reply how these are to be treated.
May I just ask for some clarification so that I can better address in reply what the submission is? Are you asking the question as to what is going to happen to monies in the custodial bank account, insofar as the Minister of Finance, qua Treasurer, qua Treasury, has the authority to treat with those monies? Is that the question?
That is how I'm thinking, yes. And I'm expecting that you will correct me, that the Honorable Attorney General will correct me in his reply. I am unable to determine from here that monies which arrive in the consolidated fund via my interpretation of the Exchequer Act will find its way out unless the minister is prepared to permit it to happen. May I just move forward then to, sorry, is that, no?
Out, if I could ask you to disaggregate it, because the revenue account is one thing, that goes to the consolidated fund, and that's clear. Do you mean the revenues in trust, where they go to, and that the minister must therefore now prescribe the payment out from the custodial trust account? Is it that you're asking?
Yes, indeed. I see. May I put it in my own words? There may well be a difference. I have contended that monies which are contemplated to be placed into the custodial trust bank account under the hand, well, firstly in the name of under the name of the judiciary and under the control of these signatories, are public monies, and that public monies, from my reading of the Exchequer and Audit Act, are monies which will find their way into the consolidated fund and are controlled by the Treasury and are audited by the Auditor General. And somebody has to say, those monies are not going to be accessible by those two authorities, those two officers of the state.
Can't be huffed.
Huffed? Yes. May I read into the Hansard the word huffed? And accept it. You can't huff the money and go. There are times when only a colloquialism will do. I move forward a bit. There is in clause 5.4 of the bill the following. Custodial bank accounts, that means both the trust and the revenue account, shall be public accounts for the purposes of Section 116 of the Constitution. Now, Section 116 of the Constitution creates the office of the Auditor General and gives him power to audit those accounts. But that seems to me to be the limit of Section 5, Section 4. Maybe something more was intended. It is not enough to say that they are public accounts and therefore the Auditor General may audit them. There are going to be questions, and I have heard one raised here, of how does the Auditor General get access to those funds, unless, as it turns out, by an answer that came from the other side, from the Minister in the Ministry of Finance, I think it was, that it is possible to call upon the payer, yes, to invite the payer to have the bank give the information to the Auditor General. I think that's what I heard. I'm sure I'm not correct. But if all that Section 5, Clause 5, Clause 5.4 intended was that the Auditor General should have the power to audit these accounts, then nothing much has been achieved by that, because I said before, all of this is public money, and he or she already has that power and may use it in the ways that I have described. So that here too, the provision in Section 4 of the Clause 4 of the bill, talking about this act prevailing over the Exchequer and Audit Act in the event of conflict, is not a sufficient instrument for bringing about what was intended. Moreover, it is my view that we ought not simply to brush aside the powers that are contained in the Exchequer and Audit Act in that way. And perhaps I could take one further step to say the use of a term in the event of conflict. If it is limited merely to saying if there are language conflicts, then we go with what is said in the Exchequer Act. But I don't think so. I think it means that there are operational conflicts. And if it is not intended that operational conflicts should be encapsulated and treated by the bill before us, as distinguished from the Exchequer Act, then we need to use greater language to ensure that people understand that in its operations, it is the bill, it is the new act that is proposed to prevail over the Exchequer Act. I trust that that is not what is intended, but if that is what is intended, language is needed to give more teeth to that. I think I've spoken about the minister having power because he is what the Treasury is, according to the Act itself. And may I now invite your attention to Section 4 of the Exchequer and Audit Act, which says that those who collect public money shall obey the instructions of the Treasury and the minister. It says, I could read quickly some parts of it, all persons concerned in the collection, receipt, custody, and payment or issue of public monies shall obey all such instructions as they may from time to time receive from the Treasury in respect of public monies. Is this what Section 4, Clause 4 of the bill is intended to refer to? That if there is a conflict between yourself and the minister, that you can tell the minister Section 4 doesn't help you, you can't give me instructions? That is what I meant when I said, is it in the operations of the Act that we are talking about the bill prevailing, or is it merely in the language of the Act? In that same Section 4 of the Exchequer Act also, Sections 4.2 and 4.3, the permanent secretary to the minister or any officer in the Treasury authorized by him shall be entitled to inspect all offices and to have such access to all official books, documents, etc., for the exercise of the powers and duties of the Treasury under this Act, and shall so superintend the expenditure of public monies as to ensure that proper arrangements for accounting to the House for such expenditure are made. The Parliament, it appears, is contemplated as having some kind of supervisory authority by the Exchequer and Audit Act. Are we to accept that this bill means to empower someone other than the Treasury, the Parliament, pardon me, to have those powers, or that the Parliament should have no power over it at all? Is there not need for some clarity in that respect? Does the Parliament have any power of appropriation in relation to those funds?
Sorry, Senator, will you clear up which of the funds, trust accounts or others?
The public monies collect. Whenever I speak of it, I'm inclined not to make the distinction. Public monies are what this bill is meant to refer to, and insofar as there's a distinction made in the bill, the distinction could only be as to what constitutes revenue, that is to say by way of public appropriation, and what constitutes monies, maintenance monies, fees, I think, and there was something else that the bill referred to. So insofar as there is reference in the Exchequer and Audit Act to the Parliament having power of appropriation over revenues, then it must be made clear whether it is only such monies over which the Parliament continues to have power, and whether the other money, not being revenue, is outside of the control of the Parliament. I'm sure that there's an easy answer to that one. The Section 6 of the Exchequer and Audit Act makes a further provision. It says no public or official account shall be opened in any bank without the authority in writing of the Treasury. Do I need to repeat that? What we are talking about, what we've talked about here all day, appears to be setting up bank accounts in such bank as would permit us to to deal with them, Republic Bank being one of them. Sorry, being the only one for the time being. But there's nothing to suggest that this bill, this legislation, is subject to the Exchequer Act. So should one read it as saying that insofar as there is a power, or rather there is a prohibition against the opening of any bank account without the authority of the Treasury, this bill permits us to flout that power, that provision, and if it appears to be in conflict with what's in the bill, then the bill prevails? To me, we can't. Sure.
Repeating theme across, and again, I apologize for interrupting so frequently. I've already taken instructions and advice. The Section 4A, which came as a result of a discussion with the Treasury Division yesterday, and the CPC's department had included this, if in conflict, this one prevails position. I'm not wedded to it myself, and the position of the government is that that can easily fall. Would that removal satisfy the concern that you're last raising?
Thank you very much, Honorable Attorney General. It would in part be a good move for the mover of the bill to seek to remove Clause 4A. However, in relation to Section 6 of the Exchequer Act, if I am on the right track, I think one ought to say that notwithstanding Section 6 of that Act, the Court Executive Administrator may establish accounts in various banks and call them what he wishes, he or she, custodial bank account, custodial revenue account, etc. So I hope that makes the position clear. I welcome the expression of an intention to look once again at the falling away of 4A. But even if it were not achieved, I'm recommending that Section 6 of the Exchequer and Audit Act be specifically mentioned, and that provision be made that notwithstanding what it says, one will give to the Court Executive Administrator certain powers. That probably is the best place for me to jump off and say, I am not sanguine that the Court Executive Administrator ought to be the prime mover in determining who are signatories to this account. Clause 6 suggests that it is the Court Executive Administrator who will decide that, because of the second tier of signatories, one may be the Deputy Court Executive Administrator. So the Court Executive Administrator and the Deputy can have this control. It would ease a certain amount of anxiety in the society if it were not so. If, therefore, in Clause 6, the following three persons were named as the Tier 1 signatories, the Court Executive Administrator, the Registrar, or the Chief Magistrate, that is to say, so that both courts, the High and the Magistrates Court, may have their superior officer as an A signatory, if you want to call it that. The B signatories, in my humble recommendation, ought to be limited to those named in Romans 2 to 4, and if there are others who know full well what they do, on to 7. So that the Deputy Court Executive Administrator is not among those who are signing. There's no reason for him or her to be among the A signatories. The Court Executive Administrator is the signatory. If it cannot be that person, then it may be the Registrar or the Chief Magistrate.
Are you aware that several of those other persons listed are also contract officers and not public officers?
I used language that suggested I was hesitating to deal with numbers 5 to 7 because I had not found the time, had not had the time to determine who they are. If indeed they are contract officers and therefore are subject to influence from other places, then what I am urging is some caution in determining who the signatories ought to be. There is no need, in my view, for there to be, 11 11 possible persons from whom to draw signatories for a simple bank account. The court executive administrator, the registrar, the chief magistrate, for obvious reasons, and then 3 or 4 of these other people. If the court executive administrator is going to be abroad, he could call upon the registrar to sign. Banks follow less instructions, by the way. They prefer, what's the word I want? Huh? No, one is a bigger word than simplicity. But they prefer less instructions. You see, if the signature card has 11 names on it, you could be sure somebody going to make a mistake. And I know you will say that the electronic atmosphere we live in doesn't allow for mistakes, but I have reason to think otherwise. I have reason to think otherwise. I'm running quickly to the end of my contribution. And now may I ask, in relation to the specifics of the bill, in particular to clauses 9 to 12, which are operational, it would appear in, for the most part, I do not see, and maybe this is the antediluvian in me, any provision for the issue of a receipt to the paying person. If it is there, it is to be inferred. It has, would you, sir, would the Honorable Attorney General please point me to that part which says a receipt shall be issued by? I don't think you will find it, but you may interrupt me if you do.
Or as it's not mandatory, but it's at section 12, where a receipt is generated electronically upon payment of a sum electronically, the court executive administrator shall cause the receipt of the sum to be notified, etc., etc. So you're looking for the express statement of you are mandatorily required to issue a receipt.
Precisely. I looked at 12 with a jaundiced eye, and I thought it left it to the issuer to determine whether or not they will generate a receipt. I think the legislation ought to say a receipt shall be issued to the payer. He wouldn't have to demand it. He wouldn't have to ask any questions. Equally importantly is a provision in here that says it is his business to determine if there are errors in the record. Which section is that, buddy? The bank doesn't take the responsibility. The registrar doesn't take the responsibility. Permit me to just try to find the clause.
It's the same 12.
It might be the same 12. What could possibly impel the drafter to place on the member of the public and not on the officer of the state this duty? Where a receipt is generated electronically upon payment of a sum paid electronically, the court executive administrator shall cause the recipient to be notified of his duty to check all entries on statements, acknowledgements, or receipts and to report promptly any apparent error or possible unauthorized transaction to the court office. Firstly, at the very least, we know that the drafter is aware that errors and unauthorized transactions may occur.
The receipt only goes
and that is a concern that we all have. I do not accept, and that's once again because I am over 50, 60, close to 70, that I am not aware that errors don't occur in electronic transactions. Nor am I aware that when it happens, it's what? One of the speakers was saying, oh, well, nothing will happen. It's electronic. Everybody will get word of it. The bank will have the amount. The court payer will have the amount. The recipient will have the amount. But that is not so. That is not so. Many a slip between the CUP, the CEA, pardon me, and the bank. Well, at least 3 of us did some literature. I was saying there's many a slip between the CEA and the bank. And so I am urging that there ought to be some consideration given to either and or the bank and the court executive administrator having a duty to A, ensure that there are no errors or unauthorized transactions. It should be their duty to check all entries for that purpose, not as Clause 12 contemplates, that it shall be the duty of the paying person. Moreover, I am urging that it should be made clear in the legislation that errors or unauthorized transactions do not result in a detriment to the payee or the payer. In other words, you don't lose your money. If you go to the trouble of learning how to do transactions electronically and have them done, your anxieties should be allayed by the fact that the legislation says it's not your problem. Somebody has to pay you back your money or pay the money to you, and it is not you. The payer doesn't have to pay it twice. He doesn't have any duty to check to see if it reached where it's supposed to reach, if you permit me to speak in that fashion. It should be the duty of the bank or the court executive administrator to ensure that errors and unauthorized transactions do not lead to a loss to either the payer or the intended recipient of it. There should be a duty also on either the bank or the executive administrator to ensure that the true intended recipient is the beneficiary. In Trinidad and Tobago, it won't surprise anybody that for each of us there's somebody with a name similar to us, somewhere. It happens, and you'd be surprised. I thought I was the only one with my name. You, well, if your name is Paul, well, chances are that there are many others. And so the true intended recipient may well find himself on the short end because the money was paid out to another Paul Richards. And I don't know. Once again, I'm saying, anytime you hear me talking about electronics, I have no idea what it is about. If it works, fine. I am going on the basis that it may not work. Or it may work to the benefit of the wrong person. Technology fails. You know? And let us try to avoid that. I have read in the newspapers of banks having to close down the ATM over the weekend and people lining up all over the place. Doesn't that happen? I assume there's some electronic failure, unless it's somebody interfering with the thing, which is equally to be considered. Let me hurry up and finish before I have to sit down. So there must be a duty on the bank and the court executive administrator to introduce safeguards. There must be a duty on the drafters of this legislation to consider introducing some kind of criminal law oversight where miscreants become involved and deign to benefit from interfering in the electronics. There should be a duty on the bank to take steps, corrective action otherwise to correct errors, and not put the blame on the payee. Penultimately, I do not see any provision in here for, as Clause 10 calls it, records of maintenance orders, deposits, etc., to be much obliged to you, Vice President. For the storage of these records, their custody, their validity, how long are they going to be valid for, how long are they going to be required to be stored? It may be the fact that I don't understand what's happening in the new world, that people don't need to store records for any length of time because electronics makes it permanent, but I doubt. I suspect that records can be lost. I suspect that hacking is not new or unknown. And if the records are lost, the man who has left Roxborough and wants a point 14 to pay the money ain't going back. You will have to lock him up. I am satisfied that that would be so. And finally, Mr. President, the concerns expressed by the Law Association of Trinidad and Tobago and by Senator Chote and by Senator Ramdeen and by Senator Hosein are all concerns that I have, more particularly about the fact that the Law Association has not had the full benefit of an opportunity to conduct its own diligent search of the impacting legislation to ensure that we are embarking on the right track. If that could be attended to, I should be happy to once again express my enthusiasm for embracing this approach. Thank you very much.
Honourable members, I think now is a good time to take the tea break. So as such, this House will now stand suspended until 5:20.